We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and before the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, good morning, and welcome to today's remote sitting of the Appeals Court. I'm going to begin by introducing the panel to you. My name is Ariane Vuono. I'm joined today by Justice Gregory Massing and Justice Kenneth Desmond. Just two quick reminders before I call the case and we hear your argument. Each side has 15 minutes to present their arguments, and there is no rebuttal in the appeals court. If we experience any technical difficulties, just be patient. They generally get resolved pretty easily and pretty quickly. If we do have any, I can assure you that you won't lose any of your time as a result. So the first case on our list today is John Doe, number 216697 versus the Sex Offender Registry Board, number 2020-0882. And Attorney Gauthier, please begin your argument.
Thank you, Your Honor. Good morning. May it please the court. My name is Edward Gauthier, and I'm appearing today on behalf of John Doe. Mr. Doe is appealing from his level 1 sex offender classification. We have raised one issue, and it revolves around the requirement under the substantive due process to require Mr. Doe to register as even a level 1 sex offender where he committed his sex offense in 1994 and has resided in the community for 25 years without committing a sex offense. And before I begin the argument, I would point out that it was unable to make my brief because I briefed it before this case, but Justice Massing was part of a panel, Doe 523671. The case is 19P1638. It is an unpublished Rule 23 decision issued in January of this year, but it is almost identical to the facts of this case. That was a 1993 sex offense. The gentleman lived in the community without committing a new sex offense for 25 years, was required to register as a level 1 sex offender, and this panel of this court in an unpublished decision decided that given his time in the community offense-free, there's simply no rational reason to require a person to register as a sex offender.
Let me stop you there, since I do remember the case. And that case was a little different because in his brief, he was challenging the board's decision that there was any evidence, that there was substantial evidence to support a level 1 classification. I don't see you making that claim here. What I see you making is a substantive due process claim, and what it seems to me is you're making it for the first time on appeal.
This was not raised below. The difficulty with substantive evidence claims is that with the exception of extremely extraordinary cases, which are probably 1 in 10,000, administrative decisions by administrative boards in the Commonwealth are almost never actually struck down by the courts. I've handled many of these cases, and frankly, it simply does not happen with sufficient regularity.
Right. So in that case, I mean, the case was not an all-40 because in that case, there literally was no evidence about the offenses in Oregon. And right. Here, there is evidence about the offenses in Ohio, and you're not challenging that evidence. Aren't there ways? If your client really presents no risk of reoffense, aren't there ways through the process to get him relief from registration?
The only way for an individual to get relief from registration is an establishment that there is no risk of reoffense. And obviously there is a little difference between no risk, low risk, and these words aren't defined anywhere, but to actually make a claim that there is no evidence of a low risk of reoffense is very hard. And it really can only happen in the case like Doe 523671, where the board simply didn't even have any records establishing the underlying facts. Nonetheless, in that case, the board had the benefit of the statute. And at the very least in that case, the statute was met because a conviction entered. So it was definitely clear that in that case, Doe sexually offended against 2 minors and committed statutorily defined sex acts on those children. So even though there was no underlying facts by way of police reports, the board could have found in that case that certain acts by definition must have taken place against certain victims.
Let me ask you a question, if I may, Attorney Gauthier. I'm not familiar with that particular case that was issued under our Rule 23.0, but of course I'll take a look at it. It would only be a persuasive value, not precedential value anyway. But I'm curious whether or not in that case, Mr. Doe had a significant criminal history and other risk factors that are present in your case. In other words, it is true, as you pointed out, that your client has not been convicted of any sexual offenses in the last at least 2 decades, but he has certainly a substantial criminal record, and which also involves some, it looks like some dependency on alcohol.
Well, that is correct. There is a difference. My client, Mr. Doe, has substantial criminal record that predates his 1994 sex offense, going back to 1980. Since he was released from the Ohio House of Corrections in 1996, however, he had a 2018 assault and battery that was eventually dismissed, as well as a 2008 offense. So we're looking—
Only because, of course, his wife at that time refused to testify, right?
Well, the case was dismissed and the wife did assert her privilege.
That was a domestic violence case.
That was a domestic violence case, correct.
Okay. And he also had some alcohol issues throughout those years?
There is evidence based on his convictions from 1980 to 1996 that some of his offenses were driven by alcohol, and the 2008 case I establishes that he was consuming alcohol at that time.
So he had multiple criminal offenses through multiple states with multiple victims, and he had some uncharged conduct with the sister of this victim, for which he's been a registered offender, correct?
Well, there is some factual dispute about that. The hearing examiner found that he committed a sex offense against the 14-year-old sister of his index offense, but that there wasn't a conviction. However, looking at the records, the hearing examiner may have erred. There may have actually been a conviction entered. It's difficult to discern the record, but the hearing examiner may have made a mistake in that regard. But again, that was 27 years ago. And the question is, it's a present question. What risk of reoffense and degree of danger to the community based on the likelihood of committing new sexual offenses does he pose? Well, he's managed to live in the community for 25 years without committing a sex offense, without the benefit of a registration requirement. The purpose of the registration requirement is to decrease the likelihood that he will commit a sex offense. If he's been in the community 25 years without committing a sex offense, how can we say that requiring him to register, mail in a form to the board once a year is actually going to fulfill a statutory purpose of protecting the people in his community?
So the argument is, as applied, it's unconstitutional to him.
It's irrational as applied. It's irrational as applied to any person who has managed to not be charged with, accused of, or convicted of a sex offense for a quarter of a century, to now say, oh, we believe that the safety of the community requires you now at this juncture, at the age of 55, even though you weren't charged with any sex offenses for a quarter century, we now believe that you mailing a form to the board on an annual basis, letting us know of your current address, that provides a measure of protection to the community where there's been no sex offenses for 25 years. That smacks of irrationality. The idea that the community is somehow safer today, post-hearing, than it was pre-hearing, there's nothing to support that, and it's
well, part of course of the requirement that one mails in and gives their address is that also that local law enforcement knows where he is at that time in case anything else develops, right? I mean,
Well,
that's part of the safety of the community, right?
The board does, in its brief, mention that the justification is that if Doe became a suspect or were accused of committing a sex offense, mailing the notice once a year to the board would give law enforcement the information it needs to find him. But essentially, we're talking evaluating the due process rights of clients, of offenders, and we have the community protection where we give notification, we have active dissemination, and the purpose of that is to prevent John Doe or any sex offender from committing an offense. There's nothing that the board is arguing that by requiring him to register as a level 1, mailing that form in once a year, it will actually protect the community from the commission of sex offenses. Rather, it's a tool, a law enforcement tool, that in the event John Doe were to commit a sex offense, well, they have his address on file and they can go find him, they can interview him, interrogate him.
Isn't that in and of itself, can't that in and of itself be a deterrent for him?
But he went 25 years in the community without committing a sex offense without that deterrent. So we don't understand what the purpose, what the need or purpose of this deterrent.
But that doesn't answer my question. Isn't the fact that he could be quickly discovered, couldn't that act as a deterrent for him for committing another sexual offense?
Well, I think the literature that the board relies on for determining whether an individual is a risk of reoffense or danger to the community would point to factors that are unrelated to the likelihood of detection, because
so your answer is no? I'm not sure what your answer is. Yes or no?
My answer is no. I don't believe that the fact that people commit sex offenses for myriad reasons, and it is unlikely that a person who is inclined to commit a sex offense would not commit a sex offense, especially if they've committed sex offenses against children simply because the board knows of their address. I wouldn't accept that would provide a deterring effect. No.
The hearing examiner determined that some of his conduct constituted or amounted to antisocial behaviors. Would you agree with that?
Well, there's a DSM-5 definition of antisocial. I would not agree with that. I would agree that he has a substantial criminal record, however. He clearly does. I mean, there's no hiding from the entries on his Board of Probation record and on his III interstate index. They are what they are. They come from 1980 and essentially run to just a few years ago. So he does have a history of a variety of larceny offenses and domestic offenses, but the board registration requirements don't exist to protect people from larcenies or antisocial behavior or even domestic violence. They specifically exist to protect the community from people who are likely to commit sex offenses. And John Doe simply at this stage isn't likely to commit any sex offenses.
Okay.
If there are no further questions from the panel, I would rest on my brief.
I'll check with the panel. I see no further questions. So thank you very much. And we'll turn now to Attorney Chanel. And before we do, I'm going to apologize. I see that with the sunlight coming in, where I'm participating in this argument is turning me somewhat into a ghost upon occasion. I don't want this to go viral like the cat video, so I'm just going to say right now I'll fix this in between now and the next argument. I just hope it's not too distracting to you, Attorney Chanel. Apparently, Attorney Gauthier was not distracting to you. Your argument went along very smoothly.
Judge, I have my own issues on this end for myself, so I'm not distracted by anybody's situation.
All right, go ahead, please, with your argument.
You know, the board's position is that there's no unconstitutional application of this, of the level 1 to this individual because the evidence supported the level 1. And the reason I say that is because although he hasn't committed a sex offense in 24 years, there's two things that are interesting. Aside from the fact that he has a lengthy criminal record that went well into the early 90s in 5 different states. But he was actually being classified in Massachusetts in 2008. He left the state, moved back to Ohio. And when he did, we stopped the process because we no longer had jurisdiction. And somehow 10 years later, we find out that not only he was somehow back in Massachusetts, but he committed a domestic A&B and was being held at the Hampshire House of Corrections. And what's interesting about this, he came back to the state and never notified the authorities in this state that he was back in the state so that we could continue the process for classification. So clearly there's evidence that this individual was at least trying to evade the sex offender registry law. And again, the level 1 classification does have import for the state and for the protection of the public. The first import is that he has to annually register, but most importantly, it allows both law enforcement and the board to keep tabs on him in a way that should his behaviors change under the classification regulation and some of the factors that would indicate his risk is rising or his danger is rising, the board could then bring a reclassification based on the new information, as opposed to waiting to him to commit a sex offense, get convicted, and start the process over again. And in this case, I think that domestic A&B is what prevents this case from not being a level 1, from the difference between not having to register and the level 1, I believe really focuses around the fact that he committed the domestic A&B in 2017. So he's still showing criminal behavior. He's showing hostility towards women. These are high risk indicators of both antisocial behavior and risk and danger elevating behaviors. And I think that's where we're at the level 1. The question is to look at is whether or not a reasonable mind can determine that he does have a low risk and a low danger at the time of the classification hearing. I think that really is the board's position in a nutshell. And if, unless there's other questions, the board would rest on its brief on these issues.
I have a few procedural questions.
Sure.
One of them is the argument you made about him leaving the state and the board had tried to assume jurisdiction and he left the state. You make an argument, you mentioned in your brief that was not in the record. You had some citation to section 14 of chapter 38 that we should look at it under that guise. Was that introduced in any proceeding?
It was not introduced in a proceeding. It was, but I wanted to clarify the issue because the plaintiff's brief kind of alluded to the fact, but made it seem like that the board had waited all these years to classify this individual when that really wasn't the case. We had started the process in 2008. He just left the state and we at that point stopped the proceedings because we didn't have jurisdiction. So I was trying to clarify that point, that this wasn't a case where he'd been living in the community in Massachusetts for 15 or 20 years.
So just procedurally, so you're introducing the fact was for the first time on appeal.
Correct. And I'm introducing it under the idea of clarifying the record as opposed to anything. It was mainly that was the point of the procedure.
Understood. So he's not arguing that the evidence doesn't support a level 1. He's sort of conceding that the evidence supports a level 1. He's making this substantive due process argument. Why didn't you don't assert waiver?
Well, because I think when you're dealing with, I was thinking in this case, we're really dealing with a substantive due process issue, which is a constitutional issue. I could have asserted waiver. I really focused on the fact that in these cases, making a facial challenge based on substantial or substantive due process, you got to show that the underlying decision as applied to this person was somehow constitutionally invalid as it applied to him. If the facts support the level 1, that can't be the case. And the procedural due process is easy because he had his procedural due process rights. I think it's really hard for a litigant to claim a facial substantive due process issue. I just find that a very hard burden to overcome.
Well, I think he says in his brief that he's only asserting it as applied to him.
Correct, and then that's what I'm saying. If the level 1 was legitimately applied by the board, there cannot be a facial constitutional challenge to it because it hasn't been, the regulation hasn't been unconstitutionally applied to him. I think that's the underlying premise. I mean, you can't, if the board's actions were valid, there can't be a substantive due process violation, even on especially on a facial level.
Right. You know, there's a Justice Corey decision from like about 2008, and then it was taken up by Justice Walahojian a little bit later that says if there's no evidence whatsoever of a risk, then it's some sort of constitutional violation. What was that, substantive or procedural?
That was I believe it was DO 974, and
Of
that
course
was
you know the number.
I could be wrong. There's been so many numbers since that time, but you know what they were arguing in that case was the board said, look, the man wanted to have a hearing. We made him a level 1, and back then we were arguing because our regulation doesn't allow people who have lifetime registrations to be relieved, he didn't really have the right to a hearing. What the court said is, no, he still has a right to hearing to show whether he poses risk or danger. I think the end result, at least my reading of the case, is that the board, even with lifetime registration, still have to show current risk and danger. If there's no risk and danger, even lifetime registrations cannot stand. I believe
is that as a matter of substantive or procedural due process?
That's more of a procedural due process issue. It was getting the right to have a hearing, even if the individual was on a lifetime registration portion of the statute. And, you know, in that case itself, I think did result in the board reassessing and saying, okay, if they can show no risk or danger, we will relieve them even if they have a lifetime registration.
And now there's subsequent SJC decisions that if the claim is that he poses no risk, the board actually has to show that he poses some risk.
Right, and again, we have to show that by clear and convincing
evidence. Yeah.
I mean, the courts in the last 3 years, the SJC especially has moved towards requiring the board at all levels to prove by clear and convincing evidence. So in this case, it comes down to, is there clear and convincing evidence at the time of the classification decision that indicates this individual poses a low risk and a low danger? And of course, the board's position today is it does. And if it does, there's no substantive due process issue.
Thank you.
So if there's no other questions, I'll rest on my brief.
All right, Commissioner, one moment, and I'll double check with the panel to be sure there's no follow-up, and I see no follow-up. So thank you both very much for your arguments today. They were very helpful, and we'll take the case under advisement.
We are live.
Okay, thank you very much, and good morning, and welcome to today's remote sitting of the Appeals Court. I'm going to begin by introducing the panel to you. My name is Ariane Vuono, and I'm joined today by Justice Gregory Massing and Justice Kenneth Desmond. Two reminders before we begin argument today, and that is you each have 15 minutes to present your argument, and there is no rebuttal in the Appeals Court. You can be assured that we've read the briefs and everything that's been submitted to the case thus far, and so we're familiar with your case, and you can get right to the points you want to make. Upon occasion, we have some technical difficulties. They generally get resolved very quickly. If that happens today, just be patient, and I assure you that no one will lose any time as a result of any glitch that we may or may not encounter. So this case is Dorothy MACAULAY versus Christine KINNON and others. Number is 2020-0058. Attorney Bell, you are the appellant, correct?
That's correct.
Okay, you may begin your argument.
Good morning, Madam Justice Vuono, Mr. Justice Massing, and Mr. Justice Desmond. May it please the court, my name is Ronald Bell, and I represent the law firm of Bernstein & Bell, the appellant in this case. This case comes to the court on appeal from the judgment and orders of the Middlesex County Superior Court, insofar as they concern the amount to be awarded to the law firm of Bernstein & Bell under a valid attorney's lien. The lien is on the $58,000 plus the proceeds awarded by the United States Bankruptcy Court for the District of Massachusetts to Dorothy J. MACAULAY, the law firm's former client, who was a creditor in the bankruptcy proceedings and is the appellee on this appeal.
Attorney Bell,
Yes, sir.
is it true that your firm has been paid $78,000 or over in attorney fees by Ms. MACAULAY?
It is true that over 10 years, we received about $73,000, I believe, in money and applied another $5,000 for a total of $78,000 in money and credits from Ms. MACAULAY.
And if you prevail to recover the lien amount of $58,000, at the end of the day, what has Ms. MACAULAY recovered? What has she achieved?
She achieved the use of an easement area that she was granted in 2002 from the defendants, the Department defendants. In 2004, the Tewksbury Board of Health issued an order for her to remove her animals and sheds and so forth from the easement area. I was able, when I was retained in 2006, to continue abatement of that administrative order for 10 years. I also was able to successfully process the proof of claim in the bankruptcy court, which was in the amount of $1.9 million, which the trustee and the bankruptcy court judge approved for Mrs. MACAULAY. So that the $58,000 is a reduced amount of proceeds based on the actions of the defendants in the De Palma case, as found by the trustee when he concluded that they had engaged in preferential and fraudulent transfers in order to avoid having to pay Ms. MACAULAY on her claim. So that's what Mrs. MACAULAY has paid and what she would garner from this proceedings.
In the end, however, you have to, it would be your burden, you agreed to establish that the judge here abused her discretion in determining that you should receive only a portion of the $58,000 amount.
Yes, that was the issue, abuse of discretion and errors, clear errors of law.
So if you could help me out, I'm having a little difficulty of determining how it is when the judge determines that in the end that your fees were excessive to a certain extent, and that you really only earned about $400,000 or so in terms of what the judge considered to be reasonable. And then she develops a mathematical formula that you quibble with, because I believe is mostly because she starts with the $400,000 amount and you start with the larger $1.2 million amount that it was noted by the trustee, right? Do I have that? Do I understand that correctly?
The judge seemed to she disallowed or reduced the claimed attorney's fees that were over $800,000 by about $500,000 on the grounds that the appeal was caused by counsel's misconduct in the first trial. This court, the appeals court, considered that appeal back in 2012 and 13 and determined that the trial judge had other less drastic alternatives and should have used them and overruled the judge's dismissal of the case and returned it for trial before a different judge.
But
So-
that decision didn't say anything about the fact that the mistrial was not caused by your conduct, right? In other words, the judge had other options, and
That's-
the one that he chose was the most drastic. But it was still caused by, let's call it a misstep or misunderstanding instead of something intentional. Let's put it that way, right?
That's correct.
Okay.
But if Judge Kazanjian, dealing with the attorney's lien, determined that the appeal, the time spent on the appeal and also preparing for the first trial was all work unnecessary. If the appeal had not been taken, the case would have been over. And as it turned out, the appeal was taken. The appeals court decided that the case should not have been dismissed, and as I said, returned it to a different judge for trial. The deduction of the work to prepare for the first trial, I think the judge erred in deducting that from the overall claim of attorney's fees, in that the result of preparing for a trial ought not to be deemed to be work not necessary, no matter how the case turns out. So I think that the deduction of $500,000 in legal fees from the overall claim was error. However, if you get to the roughly $400,000 left of reasonable attorney's fees, I think that's where the court should have, under the Massachusetts Supreme Judicial Court's guidelines, applied the lodestar method to determine what the fee award should be. So you get from 800,000, I suggest unfairly, down to 400,000. Still, that ought to determine the reasonable attorney's fees that the firm is entitled to. Instead, the judge decided to apply a formula to reach a proportional division of the proceeds. Now, the case law that's cited in the brief indicates that that is not the proper procedure that should be followed. She should have, when she reached the reasonable attorney's fees of roughly about $400,000, she should have looked at the proceeds and said, in fact, in the transcript, she started out her decision at the end of the hearing by saying, if Ms. MACAULAY owes the law firm $58,000, then that should be the lien. But then she expresses her sympathy with the frustration that the client had with the fact that the case didn't go to trial.
Alert from calendar.
The case did not go to
Sally's birthday.
The case did not go to trial before one of the defendants filed for bankruptcy. And if it had, MACAULAY might have gotten the $1.9 million that the trustee in the bankruptcy court found was a legitimate claim.
So can I ask you, the purpose of the attorney's lien is so if the client gets a nice recovery based on the attorney's work, she shouldn't be allowed to stiff the attorneys, take all the recovery for herself and not pay the attorneys. Do you have any case where the attorney's lien gives the attorney the entire judgment?
I'm not sure about the entire judgment, Your Honor, but I cited in the brief several cases that stand for the proposition that the attorney's lien may exceed the recovery. Let's see if I can find those those particular cases. It's in one of the footnotes that I'm looking for at the moment. Yeah, several cases, footnote 104 of the brief, Your Honor. Several cases support the proposition that an award of attorney's fees may be disproportionate to the amount recovered. And that's Diaz v. Genton.
Okay, thank you. That's, I'll look at those at note 104. That's helpful. Thank you.
You're welcome, Your Honor.
But so, I mean, she's paid you so far money and credits of $78,000 for recovery of, it turns out to be, because of the bankruptcy, $58,000. With the lien that you already have, now you'll get $109,000 and she'll get $27,000. But you think it's more fair and reasonable for you to get $136,000 and her to get nothing.
If you divide the $78,000 by the over 300 or $3,400 hours, it works out to be roughly $23 an hour, where our agreement, fee agreement, was for $225,000 an hour at the beginning, and it went up slightly after that. So if you add the amount of the bankruptcy court award, I think that would result in about $40 an hour. So either the $23 an hour that presently exists, or the $40 an hour that would exist if the court awarded the entire proceeds to the law firm, is well under the agreement that the client had with the law firm. And
how many hours over the course of 10 years?
3,400 hours.
3,400.
Yes.
That's basically, that's like 10 hours a day for almost a year. I mean, 10 hours a day for a year, not with a couple of weekends off. Okay.
Well, yeah. I was just looking for the breakdown.
Even if that's true, at the end of the day, she walks away with nothing and you walk away with over 100,000.
Well, I don't know if walk away is quite the right terminology, but yes, that's how it turns out. If you apply the law to the facts, then that's what it works out to be. I was just looking for.
You didn't quite answer Judge Massing's question, though, whether or not you think that that's fair. You explained the background and per hour, but I'm assuming by how you responded thus far into Justice Desmond's question that you do think that that's fair.
I do think it's fair. In the 10 to 11 years that MACAULAY was represented in the three matters relevant to the attorney's lien, counsel was opposed by 9 different law firms, conducted and responded to extensive discovery, including lengthy depositions, proposed or opposed over 100 motions, including successfully opposing motions to dismiss and motions for summary judgment, appeared in court and before governmental bodies over 50 times, prepared for 3 trials, prosecuted a successful appeal, and for 10 years successfully forestalled the Tewksbury Board of Health's efforts to enforce its 2004 administrative order concerning MACAULAY's use of an exclusive easement. Finally,
She argues that much of that was at your own making, and none of that was at her direction, and all of that was not in accord with what she was asking you to do.
well, I obviously disagree with that. We pursued that case and devoted the time to get ready for the trial in 2011. But for the judge's overreach, as the appeals court found, we would have ended the trial in 2011 and hopefully had a successful result. As a final point as to what counsel accomplished, counsel successfully established Macaulay's full claim in the total amount of $1.9 million as a creditor in bankruptcy, which resulted in the proceeds upon which the attorney's lien attached. It seems, though, that since there was only $58,000 in proceeds, that somehow is, Ms. McCauley is somehow indicating that that was not a success. And
I'm going to have to stop you there because your time has expired. But I will check to see if the panel has any follow-up questions for you before we hear from Ms. McCauley. And seeing none, okay, so for the remainder of your arguments, you can rest on your brief.
okay,
Ms.
thank you, Your Honor.
McCauley, it's your opportunity to tell us your side of the story now.
Good morning to all the judges on the panel. Thank you for allowing me to speak. I would like to start with the scheduled trial that was in 2011. I received a phone call from Attorney Bell, and it's in my brief, that he wanted to cancel that trial. And I said, no, absolutely not. This case has gone on long enough, and I want the trial. Attorney Bell then informed me, he said, the case isn't ready. I said, the case is most definitely ready. It's been ready. It should have went in 2008 before Judge Walker, except Attorney Bell's opening statement was, I believe, 11, possibly 12 times I saw Judge Walker mark down each time Attorney Bell mentioned the financial status of the defendant, Maureen De Palma. He caused the mistrial, and in 2011, he informed me that the case was not ready to go. I disagreed. Then he said that I wasn't ready for a trial. I said, I'm more than ready. I've been waiting, and I've been telling you, get this case to trial. Then Attorney Bell said he's not ready. And I disagreed there. I said, you were ready to go in 2008. We should be ready to go now, move the case to trial. And then Attorney Bell came out with that either I agree to him postponing the trial or he will withdraw and I will get nothing. That was the first, shall I say, in my words, threat, the first from Attorney Bell. I never, in all the years that he was representing me, I was constantly and continually verbally saying, get this case to trial, because he was accruing.
I just want to be sure, Ms. McCauley, that these are the same things that you told the judge when you appeared in Superior Court with respect to the attorney's lien. Because we can only consider things that you told, that were told to the judge at that point in time with respect to whether or not the attorney's lien was appropriate or not, and how much of that it was recovered from the bankruptcy proceedings you were entitled to.
Yes, I did.
Okay.
I did express to Judge Kazanjian
Okay.
more than once that I never gave him permission to not, he just would not perform a trial. And Judge Kazanjian could clearly see that for herself, that I couldn't move him. I cannot force him to perform a trial. And what was worse was where I was a client, I could not speak. I knew what was going on behind the scenes, and it's all in my brief.
Did
what
you
was
say,
taking place behind the scenes?
did you say in your brief that at one point he was only seeking 15,000 of the $58,000, Ms. McCauley? Did I read that correctly?
Yes, after Judge Panos in bankruptcy court, looked directly at Attorney Bell and said, it appears you have your own best interests in mind and not that of your client. Judge Panos then suggested that we both get together and maybe reach a compromised agreement. Attorney Bell had already pre-drafted an agreement prior to the meeting, and he wanted 15,000 of the 58,000 that is now being held in Woburn Superior Court. I said, no, I paid you $10,000 for an appeal. And he's in contempt of the appeals court order for all those years from June of 2013, when the appeals court put the order to send the case back to Woburn before another judge for a trial. Attorney Bell remained in contempt of that order and his client's verbal and written instructions, because all the way up until he withdrew in bankruptcy court, he withdrew to go after my damages. And then the last hearing, when he couldn't get my damages from the trustee, 3 times at the last hearing, he wanted me to rehire him back. Well, I'm not rehiring him back. I'm not going to be abused again. No. So yes, Judge Panos suggested that we compromise. I refused because I paid him it was $78,700 to be specific, just on the department case. In total, the 4 cases that Attorney Bell had, he withdrew from 3, was court ordered when the case returned from bankruptcy court to Woburn Superior. He was court ordered when I proved that he made false statement in writing in a motion to keep department in the case necessary for adjudication. He put in writing in the first paragraph, counsel to the plaintiff. And he went in that morning and he stood right aside of me. He looked Judge Inge right in the eyes. And as they introduced themselves down the line, Attorney Bell was last, and he said, "Good morning, Your Honor. Attorney Ronald Bell, counsel to the plaintiff." And that is when I had enough. False statements since I retained him in August 2006 are fluent. Being in contempt of court orders, not a problem. Who's going to find out? The client can't say anything. It wasn't until his withdrawal in bankruptcy court to go after my damages that I was free, finally free. And I started saying what was taking place behind the scenes. And it is, in my words, horrific. Judge Inge's order, one of his first orders, is that it was long and tortured, after what I divulged to Judge Inge at that first hearing. And his order following up that, clearly, he put in words, long and tortured, referring to the department case.
I'm going to ask you another question regarding what the judge did here in terms of how she allotted the award. And so I take it that you're willing to accept what the judge did ultimately in awarding you $38,000, I guess it is, correct?
Actually, no, I'm not. I have proof that Attorney Bell is once again, how do I say this politely? Making false statement to the appeals court, just as he did in June of 2013.
Let me put Justice Vuono's question in maybe a different way. You did not file an appeal from the order on the lien, right?
Yes, I believe I did file opposition.
No, but did you file an appeal, a cross appeal?
I'm sorry, my mistake. No, I did not.
Okay. So one of the things, you know, as an appellate court, we don't quite have the same jurisdiction as the trial court. And so that's why we're sort of asked you to focus on what was argued to the judge, Kazanjian, and, you know, and below. But I noticed that you filed several motions with us. And one of them is a motion for an investigation of things that are missing from the transcript. Now, you know, I'll tell you, that's not the function of the appeals court. We don't find evidence here. And you know, if there's something that's wrong with the transcript, you actually have to go back to the trial court to get that fixed. But let me just ask you, what do you say is missing from the transcript that might be relevant to the appeal, if anything?
Calendar. Lynn Marcello's birthday.
That is in the motion. I listed everything that's wrong with the transcript. I also went back into,
Can you remind me what are the things in there that are missing that are important?
approximately 1/3 of the evidentiary hearing in its entirety.
So what was said what was said there that would be important?
I would say one of the most important things was when Judge Kazanjian directed a question at Attorney Bell and Attorney Bernstein. And it was approximately near the end of the hearing. And she asked both attorneys, where you didn't bring the case to trial, how did you expect to get paid? And both Attorney Bell and Attorney Bernstein stood there, me knowing both of them, they had a guilty look and they never answered her question. She was the first judge, besides Judge Panos, she was the first judge to nail it right on the head. He had all these years to bring the case to trial, and he would not follow my instruction. He would not follow court's instructions that the case was to go to trial. And I'm accusing him of intentionally dragging out the case with numerous motions and accruing compounded interest against Judge Salinger's November 24th, 2014 decision. And then to try to correct the situation, he filed a motion, a stipulation to waive expenses and fees. Because he was in direct contempt of Judge Salinger's order, and he got caught. So instead, to make it look good, he wrote that motion to waive the expenses and fees. Everything I will say right now, to every judge on this panel, I personally thank you for your attention to this matter. But the fact is that I could not move Attorney Bell. He would not follow verbal instruction. He would not follow numerous written instructions by letter. And he would not follow court orders. And I couldn't say anything. I was stuck in the middle. And I refused to basically release him because I know that he would have just kept my $78,700 and I would have no recourse. If Attorney Bell, what he's trying to do, and I have proof by way of his appellant brief, what he's trying to do right now is in his own client fee agreement, appellant brief number 151 on page 153 under number 12, he is not entitled to a lien per their own contractual agreement. It says under, if I discharge the firm, then the firm shall have a lien on the amount of any proceeds recovered by the client. I never discharged the firm. Number 11 above says payment upon withdrawal of firm. And it says nothing about the firm being allowed to place a lien on the amount of any proceeds recovered by the client. He is seeking a lien, but indirectly he is using the court to uphold that lien. And by upholding that lien, he is breaching his own client fee agreement. He's using the courts again, is what is happening. And that is why he's after the $58,127.74. He is using the court as his excuse to breach his own client fee agreement. It's right there under number 12. He is trying to incorporate what is under number 12 under number 11, which is the withdrawal of the firm. And it's not there.
All right, well, I think we've heard all of your arguments. Your time is just about up. You only have 10 seconds left. So what I'm going to do, Ms. McAulay, is just ask the panel if they have any additional questions for you, any follow-up questions. And I see Justice Massing does not, Justice Desmond does not. And your time has expired. So I want to thank you both very much for your arguments, and we'll take the case under advisement and we'll get an answer to you as soon as we can. Okay.
Thank you to the
We are live.
Okay, good morning and welcome to today's remote sitting of the Appeals Court. I'm going to begin by introducing the panel to you. My name is Ariane Vuono. I'm joined today by Justice Gregory Massing and Justice Kenneth Desmond. Just two quick reminders before you begin your argument. Each side has 15 minutes to present their case, and there is no rebuttal in the Appeals Court. And should we experience any technical difficulties, just please be patient. Generally, they're resolved fairly quickly, and nobody will lose any time as a result of any glitch that we may or may not have. So this case is MMK LLC versus CAREY DUBINSKY, 2020-1114. And Attorney McCarthy, you represent the appellant, correct?
Yes, Justice.
Okay. Vuono.
Justice Vuono, excuse me.
That's okay. Go ahead, please begin your argument.
Good morning. May it please the court, my name is Kevin McCarthy, counsel for appellant CAREY DUBINSKY. Your Honors, as Judge Lang had stated in the lower court, the principal issue presented by the parties in this case here, the principal issue presented by the parties cross motions for summary judgment on their competing declaratory judgment claims is whether the court can rule as a matter of law on the undisputed facts presented that MMK did or did not provide the requisite 10-day notice to the trust of the imminent expiration of CAREY DUBINSKY's option to renew. Let
me ask you one question, if I may interrupt for a second. There really is no dispute with respect to the facts, right? Just whether or not those facts as a legal matter amount to notification or not. Am I right about that? Or are there any facts that you actually are disputing?
I think that I think we're pretty well in agreement on the facts, and the ultimate core of the decision, one of the cores is there's no dispute that the letter, the notice was delivered to a location and someone signed for it. That's undisputed. But it's also undisputed that the contract called for a return receipt requested, and it's undisputed that that did not occur. That there was no return receipt requested. In fact, it was intentionally avoided.
Is it undisputed?
So it is,
I'm sorry.
Go ahead.
Is it undisputed that the tenants notified or informed CAREY DUBINSKY in March of 2018 that the notice to terminate had been sent? The notice regarding the extension of the lease?
What, in March of 2018, CAREY DUBINSKY was notified by word of by his tenant, that the landlord had told him that the lease had been terminated. I'm not sure whether he mentioned option or not, between themselves, but the landlord said that the lease has been terminated and it's over. And
when CAREY learned that, did he take any action at all? Did he do anything?
He was very surprised, and he then looked further through his mail, at which time he located the February 23rd letter. And he was very upset at that point that there was no attorney or anything happened on that, so he was the only one looking at it. And so the action he looked at it, and he thought he had lost his lease, and he'd heard from the landlord that he lost his lease, and he looked at that document and saw the date on it as February 23rd, and he thought he had lost his lease.
And did he take any action then?
At that time, which is around the 1st of April, I believe actually they had he had then contacted myself as their attorney, and saying that they'd lost their lease. I think they had also, in the record, it shows that he had made a phone call with his brother and left a message. I don't know whether it was related to this. I think it may have been related to this, this loss of lease also. But the main action that he took was he got a hold of an attorney, one of which was not available previously because none had been copied or informed of. That's what he did.
Okay, I'm gonna ask you one more undisputed fact question. There's something in the record that there was a conversation between the landlord's principal, Mr. Khalil, and your client shortly before he sent out it was February 8th, where he said, come on, you got to exercise, you got to make a decision to exercise the option. Do you dispute that conversation took place?
Not that the conversation, I believe my client said that the conversation did take place. He did dispute all the please do. He didn't remember it that way. What he remembered from the conversation, as he testified in his deposition, was that he thought he was all set on his lease, that he had another 5 years. That was his memory of that conversation.
Okay, so there's a bit of a dispute about that one.
I'd say yes.
But that was followed up by an email that had been apparently your client claimed had been unread at the time, but he didn't dispute that there was an email that was followed up after that conversation, right?
I'm not sure whether or not he ever did find that email, but in the email itself was no advisement. The email itself could be read as, go ahead and you have an option. It's still alive. Exercise it when you wish. There was no 10-day discussion or limitation of when he had to respond. So if you did get that email, you had the previous phone conversation, and you were under the impression, or you thought that you had another 5 years automatically, it follows logically and sensibly that he'd think, well, okay, there's a follow-up and I can go ahead and exercise whenever I want to. One of the objections we had with that is that was not obviously a 10-day notice under the lease. So any other questions there? So, Your Honor, I'll show is that the lower court erred in ruling that the appellee MMK provided the requisite 10-day notice 10-day notice letter, which is at issue in this case because it was defective and unenforceable. And because the February 23rd letter was defective and unenforceable, we asked the court to affirm the legality of the appellant Dubinsky's June 11, 2018 exercise of his first 5-year lease option and thus returned to him his lease in his property, keeping and reminding the court that there is a live, there is Mr. Dubinsky has exercised his option and it's right there. So if the court was to find that the letter was illegal and unenforceable, that option automatically, goes into effect.
I want to ask you about that. I want to ask you about that.
The June letter?
That's the June 11 letter where Dubinsky exercised his option.
So I want to ask you about that letter. The letterhead of that letter starts with Carey M. Dubinsky, trustee of 147 Pelham, care of Dubinsky Management Company, LLC, 5030 Champion Boulevard, Suite G6211, Boca Raton, Florida. Are you contesting that's the wrong address to send notices to?
Yes, that is not the correct address.
Yeah, that's the letter he used. That's the address he used to exercise the option.
If that was address was there and that was in the letter, is that you're talking about? That was the address of the letterhead. Is that correct, Your Honor?
Yeah. So he holds himself out as coming from that address, but yet he doesn't accept notices at that address.
Right, and the lower court early. First of all, the fact that that was put in the letterhead does not signify abandonment of his notice address. The Computone case, which we referred to in my briefs, actually addressed that in that case. They had used various addresses, and the court said that doesn't mean that the notice address that was properly provided was abandoned. Additionally, the lower court, when we pointed out that the appellee had sent a certified letter after February 23rd with a return receipt request and sent it to not the Boca Raton post office, but to the Stower location in Massachusetts, the lower court said that was okay. That didn't signify abandonment of their understanding that it was a proper address because of the flyer. So what's good for one needs to be good for the other. But more importantly, the appellate court in Computone said these various addresses the attorneys put on letterheads doesn't bind the client, doesn't lose the client their rights under proper notices.
I'm just going to ask you kind of an aside question, not super pertinent, but why didn't he just exercise the option at the 270-day mark if he wanted to renew it? Why didn't he just do it then?
As he testified to that, he thought he had an automatic extension of 5 years. He thought the lease, and he testified to that.
And so when he had the phone call with the landlord, then why didn't he exercise it then when he had the February 8 call?
He thought he already had 5 years. He thought he was all set on his lease. All along he thought he had 5 years. He was hoping to get more. What he didn't know was he did actually have more. And a number of leases that he has have those 5-year extensions. They're not uncommon. In fact, in the record, his lease with his tenant is a 5-year automatic. So it's a common thing, and that's what he thought he had. So this case, the way the court addressed it, the court treated delivery of the notice under the lease and the signature by anybody as equivalent to a return receipt requested. That's the basic error of law that we brought, one of the ones that we're bringing to the court. This is not a delivery case of a notice. This is a receipt case. We're not arguing that that the letter wasn't delivered. We're arguing that the case wasn't received, and it wasn't received because the return receipt request procedure wasn't followed. And he has an entitlement, a right to that. And the language that the court used in reasoning about the return receipt request is not according to law. The court asserts that there would make no difference whatsoever, not a whit of difference, I think the court said, if he had had a return receipt, and that it is not different at all from delivery. Well, there is difference between receipt and delivery, and the Supreme Judicial Court has said that. They said that in Andover case, which we cited, and in it, it specifically said that the purpose on return receipt is to protect property owners. So it's a two-way street. The lower court didn't recognize that, and that's an error.
In this case, how would it have been any different? Who would have signed for it differently? Even if the letter had said return receipt requested, it still would have been signed for by the individual at the UPS store, right?
Well, two things. One, he had a right to have that process play through so that if it was an error, that may have been on him. Secondly, generally with return receipts, as we all commonly know, if you're not there, they leave a notice that says you've got a return receipt, you've got to come and sign for it to get it. So I would presume that normal return receipt procedures would have occurred where Dubinsky would have gotten notification, you've got a letter here. And again, that would have allowed him to respond within 10 days. So it would have made a big difference. And in fact, he testified, it would have made a big difference. He testified that had he been able to sign for it, then he would have immediately responded properly.
You make a leap there that I don't quite follow. I mean, you can help me maybe with this. It says return receipt requested, but you say that means that it's got to be signed for by Dubinsky. I don't quite know how do you get to that?
Because in this particular contract, the notice requirement is supposed to be directed to Dubinsky. Now, if Dubinsky, and it's not this case, but if Dubinsky had set up other procedures and other methods by which his mail was received and receipts, then maybe someone else perhaps would have been responsible to sign it, and that would have been okay. That's not this case. He needs to have signed it because the contract, the lease says, and the estoppel says that the notices are to be sent to CAREY DUBINSKY, the human being, the person, CAREY DUBINSKY. So it'd have to be him that would have to sign it, or at a minimum, of course, and it would need to be directed to him. You need to have had that opportunity, which he didn't because of that loss of opportunity. And because the Supreme Judicial Court and this court, in this case I sent to you under FRAP 16 just a few weeks ago, that appeals court even elaborated further, explaining that there's a benefit to getting a return receipt. And the woman who had signed for it, unfortunately, had to be responsible for having received it because she got the return receipt. So that's just really essential. I see my time's running out. I do want to emphasize too that the address that they sent it to, the notice address that they say is totally improper. The notice address of July 2011 didn't give notification of a change of that address. It didn't name Dubinsky. It wasn't addressed to MMK. It's a very weak argument and an improper argument to say that was a proper change of notification.
How did MMK become in possession of that flyer?
That was a question I wish we had pursued further in deposition. We're not sure actually how he got it. That flyer was sent out to tenants. That post office box was set up to 7 or 8 tenants that just send their checks to it. So how he got that, we're not sure, and that's something that we should have pursued further in deposition.
And your contention is that the proper notice of address was included in the estoppel statement?
Yes, you'd either take two choices. You'd either go back to the original lease, but the estoppel statement really is a strong legal document that changed the address, and that this definitely, if you had to choose anything, it wouldn't be a flyer that would be the correct address. So the address alone was improper. It was improper.
Okay, thank you.
Thank you very much for listening to CAREY DUBINSKY's case. We'll rest on these present arguments as well as in our brief, and I believe concludes my time, Your Honors.
Okay. Thank you very much. Attorney Perry?
Thank you, Your Honors, and may it please the court. My name is Timothy Perry. I represent the plaintiff appellee, MMK LLC. The most basic fact of this case, as one of Your Honors just pointed out, is that Mr. Dubinsky, on behalf of the trust, had it within his control, his sole control, to exercise this option if he wanted to exercise it in 2 ways. The first way, obviously, was by exercising it 270 days of the expiration of the lease. The second way was to do it 10 days after we had provided the notice. And so the frustrating part for my client throughout this entire process was that he was trying to get Mr. Dubinsky to exercise this option, because having this anchor tenant in his strip mall was of utmost financial importance to MMK. He needed this tenant to exercise the option, so he knew he had a tenant in that building. And that's why he kept pleading with Mr. Dubinsky to exercise the option. And so the fact that they have made these arguments that they didn't know what was going on, or they didn't know how to exercise the option, or didn't receive these notices, again, is frustrating, because it belies all of the facts in the case, including, the letter from Mr. McCarthy, who was representing Mr. Dubinsky in April of 2018 that was cited in our brief, when even in April of 2018, they weren't trying to exercise the option. Mr. McCarthy's letter says, quote, and this is at volume 2, page 95. It's his letter. It says, "We need to establish the specific renewal terms before we can decide upon formal execution of the option." So what they were trying to do, and there's other letters to that effect from Mr. Dubinsky, what they were trying to do is leverage MMK into giving them better option terms for the 5 years. They weren't trying to exercise. That was completely within Mr. Dubinsky's control to exercise. Now, the one question I think that was legitimate that was raised in the trial court, it's been raised by Mr. McCarthy, is Federal Express service sufficient where the lease says that a certified mail is required? And that question has been answered twice by this appeals court, first in Computune and then in Gerson, and it's been cited by several other cases, both state and federal, since then. And the answer in those cases is that the function of a certified mail is served by FedEx. And the reality is, the reason is, as Judge Lang said, the exact same thing would have happened in this case, whether it was by certified mail or by FedEx. A U.S. Postal Service officer would have walked into that UPS store and asked Mr. Reyes, who is the UPS clerk there, to sign that green card. And then the package would have been placed in the box. Mr. Dubinsky's testimony is he let his mail sit in that box for over a month, which doesn't make sense. Mr. Dubinsky is someone who at one point owned and operated 26 Dunkin' Donuts stores. He was a landlord and tenant on these types of commercial leases. Trying to believe that he would leave his mail in his UPS box for over a month and miss these types of deadlines is beyond belief. But the same thing would have happened as happened with FedEx. FedEx walked in, they had Mr. Reyes sign the receipt, and we have the receipt that's in the record. So we feel that this whole exercise of both in the trial court, as pointed out by Judge Lang, when I had filed a motion for judgment on the pleadings, he had real concern that there were quote unquote factual disputes that were being raised that didn't appear to be supported by the documents in the record, but he allowed Mr. Dubinsky a short period of time to do discovery. During discovery, he admitted almost every fact that he had said was in dispute to avoid the motion for judgment on the pleadings was an undisputed fact. And so again, at that point, the only dispute really was this dispute over whether certified mail requirement in a lease can be satisfied by FedEx. And again, the Judge Lang and then Judge McCarthy really dug into those cases and all of the related cases and found that as a matter of law, that it was satisfied.
I'm sorry, Mr. Chairman, can I stop you a second? I just want to ask some
Sure.
factual questions that the other side raises. Although it calls for return receipt requested, in fact, on the FedEx air bill package here, it is checked off no signature required. And then there, I guess, it just must be FedEx's practice. They get a signature anyway. But your client didn't confirm that until later when you had a need to confirm, and then you asked them later to send you the receipt, right?
That's right. And I think that is with due respect, I think that that's a factual issue that's not material because, again, it's the exact same thing would have happened with certified mail, but apparently the landlord's leasing attorney, his practice is to send Federal Express without requiring a signature, but Federal Express, when possible, gets a signature in any event. And so a signature was obtained, even though it wasn't requested. So that's true, but I would argue that that's not a material fact because it didn't change things.
Why not just send it certified or registered mail as agreed to?
Yeah, and that's a question that Judge Lang asked, and that's what we looked at. With due respect, I think that the result here would not have been any different. As Mr.
I understand that that's not the question about the end result.
Right. I think we'd be in the same spot, though, Your Honor, no matter what, because what they're arguing, what Mr. McCarthy just said is we're not saying that we didn't, it wasn't delivered. We're saying we didn't, Mr. Dubinsky himself didn't sign and receive for it. And so we'd be before Your Honor today, even if it was sent by certified mail, because their argument at that point would be that the U.S. postal worker would have had to hunt down Mr. Dubinsky. What they're saying is that Mr. Dubinsky had to sign the green card. That's their only way around Computune and Garrison. And so they'd still be raising the argument. I understand, believe me, if it was me, I would have followed the lease to the letter and I would have sent the certified mail. I mean, but I don't think it would have changed what happened, because what really happened here is Mr. Dubinsky knew exactly what was going on. Mr. Dubinsky was using his refraining from exercising the option as a way to undermine MMK and offer him better terms. And that plays out in the letters that Mr. McCarthy himself sent to my client after the fact. I mean, Mr. McCarthy ends up sending a letter that he says is effective on June 11th saying I exercised the option, but he sent 2 letters before that saying I'm not exercising because I want better terms. That's not somebody who's acting in good faith saying I really want to exercise my option. And then in the notion that I think that the option is exercised automatically rather than sending it 270 days before the end of the lease, that doesn't hold water, because you're an experienced commercial landlord and tenant, Mr. Dubinsky. You are somebody who has had probably hundreds of these leases. You think that even though it says that you need to exercise 270 days before expiration, that his argument in this case is, I think it was automatic. I with due respect, I don't think that holds water.
We don't really have to, I mean, that's not something that's resolving that issue is not before us. I mean, that's not a material issue that's before us as far as you're concerned, correct? In other words, neither judge would have addressed that or decided who's telling the truth there, because it's not something that can be decided on a motion for summary judgment. And I think your point is that that's beyond, it's not necessary anyway, because all we do is look at what actually did happen as agreed to, and in your view, that's, and in the judge's view, that was sufficient as a matter of law.
That's right. I'm sorry.
That's
you know,
okay. I mean, I just, that,
all
those are
that.
issues that are, I think that might distract the panel a little bit because we won't resolve them.
Okay,
The landlord's 10-day notice was put in place, why?
that was, I guess, what would they call a savings clause, so that if somebody did miss that in good faith, if somebody missed the 270-day period, you didn't want, I think the term is inadvertent waiver of the period. And so that notice needed to go out in December of 2017 by Mr. Dubinsky. Okay, so then they talked about this for 2 more months until February, when my client finally went to his counsel and said, Mr. Dubinsky won't exercise. And I need to know, because if he's not going to be there in September, I need to have another tenant paying rent in September.
And so does that constitute inadvertence? Let me ask you that.
I don't think it can be inadvertence when they've had all these discussions. And then when you look at Mr. McCarthy's letters in April, he's not saying that we, by mistake, missed the deadline. He's saying we're not going to exercise this option unless you renegotiate better terms for us for the new 5 years. So I think the arguments are belied by their own statements in those letters that are attached to the record, Your Honor.
What do we do with the, I'm looking at the, there's a June 4th email where Mr. DeMakis actually responds to Mr. McCarthy, and you're still talking about what the terms could be for renewals as of June 4th.
Yes, so again, I think my client, through Mr. DeMakis's firm, was trying desperately to make sure he had a tenant for September. And so at that point, he was saying, look, you've missed your deadlines, but if we can enter into terms, we will. He didn't want an empty space, that's for sure. But I don't think that changes the requirements under the lease for exercise. And I think unless there's other questions, I think the arguments in our brief speak for themselves, Your Honor.
Okay, let me just see if the panel has any additional follow-up questions for you. And I see none, and I see none from Justice Desmond either. All right, well, thank you both very much for your arguments. We appreciate it, and we'll take the case under advisement, and we'll again respond to you as soon as we can.
Thank you very much, Your Honor.
Okay, thank you. To make their argument, what's been provided to us has been voluminous. We've gone through almost all of it, so we can tell you that we're very familiar with the case, and so you can get right to your most salient points. So Attorney Kennedy will have a full 15 minutes. I understand on the other side, there's a split of time, 10 minutes for Attorney Doherty and 5 minutes for Attorney Solomon. Am I correct? All right. And as I'm sure you all know, there is no rebuttal in the appeals court. Second, I just want to say that upon occasion, we experience some technical difficulties. We're very grateful that we can have these Zoom oral arguments, but upon occasion, they do pose a challenge. If so, the issues are generally resolved very, very quickly, and no one will lose any time as a result. All right. So with those reminders set, I'm going to call this case Daniel Petrucci versus Charles, ESDAILE and others, number 2020-0854. Attorney Kennedy, you may begin your argument.
We are here asking this court to correct the legal errors that the trial court that led the trial court to enter an illogical damages award that is completely at odds with the court's factual findings. That award permitted the defendants to walk away from what the court found in no uncertain terms to be egregious and serious misconduct, with nearly all of the proceeds of their wrongdoing intact. In a detailed and scathing set of findings of fact, the court found that the defendants committed serious breaches of their fiduciary duties. It found that once the defendants decided that they no longer wanted to share the value of Altenex with Mr. Petrucci, they engaged in what the court called a plan to cut Petrucci out of the future prospects of the business, create a new company that would keep using the Altenex name, and that to the outside world would appear to be a continuation of the same business, but that would be owned by the individual defendants and not Mr. Petrucci.
Let me ask you, Attorney King, if I may interrupt you. Didn't the judge also find that as by the time this, and I'll call it the conduct, the misconduct that the judge found on the parts of the defendants, that thereafter there was an entirely new business model, and all of the rather significant profits that were developed thereafter were based on this new business model?
The judge did make those findings that in 2013, the defendants shifted the business model. However, that is irrelevant to the case for two reasons. First of all, if you agree with us that the judge made a legal error in concluding that the contract allowed the defendants to dissolve and steal the company from Mr. Petrucci, he's entitled to rescissory damages. And as an owner of the company, he would be considered basically as though he had retained his ownership interest in the company. And as a passive owner, you are entitled to enjoy the benefits of the increase in value of your stock for as long as it's in the hands of the fiduciary that committed misconduct. And if, on the other hand, you agree with Judge Salinger's interpretation of the contract and find that this is truly just about the theft of the assets and inadequate compensation for the assets, the judge committed another legal error in applying his own standard of damages, in that he was attempting to calculate the fair market value of the assets as of the highest point in time, which he concluded was July 2011. And in doing so, he inappropriately looked at things that occurred in the future, when fair market value should be determined based on what a willing buyer and willing seller would agree to, with knowledge of the material facts in existence at the time. The defendants had no idea at the moment in time when they took these assets that they were going to change the business model in 2013. In fact, they were at the time telling investors that they had plans to go forward with the same exact business. And the judge did find that their plan was to continue the same exact business, just without Mr. Petrucci. The judge inappropriately looked at what actually occurred later on that they had no knowledge of at the time in determining what the fair market value of the assets was in 2011. And that was a legal error.
So what would your, how would you come about finding what the fair market value was as of July 2011?
If you agree that that Judge Salinger correctly interpreted the contract, which he did not, and we are looking at the value of the assets and at their highest point in time. And we agree that the highest point in time is what the judge found of July 2011, which we have also argued is contrary to the evidence. The fair market value would be based on the highest and best use of the assets at that moment in time, which was in the advisory or procurement business that the defendants were pursuing and were about to continue to pursue. The judge based his determination of fair market value in part by looking at what the defendants themselves believed the assets were going to create in terms of revenue in the near future. They had financial projections that they were sending out to investors at the time that said that the company, based on only these assets, these were the only assets of the company at the time, was worth $8 million. And that is what our expert testified was the value of the assets at the time.
And was that the value of the assets that were transferred from Altenex, Delaware?
Correct. They were transferred from Altenex, Delaware into MMS and then into Altenex, Massachusetts.
Let me ask you to talk about section 4.15 of the operating agreement. How does that not support Judge Salinger's findings?
So what 4.15 allows is competition. It allows you to engage in a brand new business. The defendants had every right to go out and start a new business from scratch, but they chose not to do that for the reasons listed in the decision by Judge Salinger. They saw the advantage of getting this 2-year head start. They basically took this business in a box, moved it over into a new container, and they were able to continue continue the business right where they left off. They chose to strip the original company of its ability to function, and competition inherently presupposes that there's an original entity to compete with. They've completely disabled MMS from being able to compete and taken the assets in order to give themselves an advantage that they wouldn't have otherwise had. This is not what 4.15 allows. Whatever it does allow, it's not that. And if it could be, even if the contract potentially could be interpreted to permit each of the individual pieces of what the defendants did to achieve this goal, which we contend it doesn't, there's no question that this has to violate the implied covenant of good faith and fair dealing. This case is on all fours with the Gerber case that is cited extensively in our briefs. It's a Delaware case where the contract there permitted the general partner of this limited partnership to do exactly what it did to eliminate the value of these assets to the limited partners. However, because that was the intent of what the general partner did, was to eliminate these assets without giving any value for them, it violated the implied covenant, because the implied covenant fills gaps even where conduct is, the procedure by which you engage in conduct is explicitly touched on by the contract. There still needs to be some standard by which we judge the discretion used to engage in those procedures. And here, there is no standard by which the defendant's behavior in choosing to dissolve the company and continue it without Mr. Petrucci was to be judged. And the implied covenant fills in that gap. They manipulated the provisions of the contract in order to deprive Mr. Petrucci of the fruits of this bargain.
At this point in time, had Mr. Petrucci, I think you say in your brief, had stepped back from MMS. Is that right? Let me start with, is that right?
Correct. He stepped back from the day-to-day operations. However, he remained.
Why? Why did he do that?
That's a great question, and we were not permitted to pursue this at trial. The reason why he stepped back is because the defendants were engaging in hostile behavior toward him that was motivated by homophobia. In their explicit emails between one another that we only got a hold of because of discovery, they expressed disdain for Mr. Petrucci because he's gay. And they that hostility manifested itself outwardly in their treatment of Mr. Petrucci to the point where he felt he could no longer participate day to day, but he maintained his equity, and the defendants explicitly stated to him after he stepped back from the day to day that they would continue to work their asses off. That's a quote from an email, to maximize the value of his equity. They knew he remained an owner, and they expressed that they were fine with that.
Didn't they initially or beginning when they started MMS, didn't they seek out Mr. Petrucci? He was a former co-worker like 8 years earlier or something. So why seek him out and then treat him with hostility? Well,
the defendants ESDAILE and Hayes were the ones that it was actually Mr. Hayes that reached out to Mr. Petrucci as a former co-worker. They didn't have the expertise in renewable energy. They knew Mr. Petrucci did. He was one of few people in the country with the level of experience in renewable energy that could engage in this type of business. They needed him. They needed his expertise. So they brought him in, they used him, they extracted these benefits from him, and once the business was up and running, once they landed Dow as their big first customer, and they had the wheels in motion and could continue from there without him, they tossed him aside. And since I'm running low on time, I'll just switch over topics to the statute of limitations issue, which is the other major issue here. Obviously, the defendants have alleged that the statute of limitations ran because they claim that Delaware's 3-year statute instead of Massachusetts' 6-year statute applies to the contract claims in this case due to the choice of law provision in the contract. That is not the case. That is not the law. The SJC decided the Gordeau decision, which is the seminal decision on this issue, in a case where there was a choice of law provision in the contract, and the court determined without any caveats or any other statements that this is what you do when you have a situation where two different jurisdictions statutes of limitation can apply. You have to engage in this functional analysis. And once we agree that this functional analysis applies, there's no contention that Delaware law should apply here. It's clear that Massachusetts has the most substantial relationship to this case and the statute of limitations in particular. And when you apply that section 142 analysis from the restatement, that is clear. And to the extent there was any doubt that that's what the Gordeau opinion stood for, this court explicitly stated in the Shamrock opinion that that's what it meant, that the Gordeau opinion stated that it stood for the principle that the party's choice of law is not dispositive when it comes to the statute of limitations, and that you must engage in this analysis to determine which statute of limitations applies. And even if the defendants were correct, that Delaware law applies, then we get to the issue of fraudulent concealment, and the defendants clearly concealed Mr. Petrucci's cause of action from him, lying to him outright as found by the trial court, that they were in a different business and were not pursuing the advisory and procurement business. He didn't learn many material facts until 2016 and others until discovery in this case. And turning briefly to the question of Chapter 93A, we also had originally brought a claim for 93A against Altenex. This claim was dismissed based on the intra-venture exception to 93A. That was error. The court erroneously concluded that because the individual defendants were members of an LLC with Mr. Petrucci, their new company also was subject to the intra-venture exception. That in and of itself is incorrect. However, especially if you agree with Judge Salinger's interpretation of the contract that it permitted this behavior, he found that Altenex Massachusetts was essentially a separate competitive entity. That is inconsistent with Judge Sanders' decision on the motion to dismiss, saying that Altenex was merely the product of their wrongdoing, and it was formed as a way of freezing Mr. Petrucci out of sharing in the assets and property of MMS. So at bottom, this claim should not have been dismissed in the first place, but if you do reach the conclusion that Judge Salinger interpreted the contract correctly, then Judge Sanders' decision on this point cannot stand.
Yeah, I know you've got a lot of ground to cover, and it's hard to choose which one. But let me ask you: could you respond to Altenex's argument that your client personally doesn't have an unjust enrichment claim against them because it's MMS's claim?
Sure. The issue there is, first of all, part of what they're arguing is that Mr. Petrucci didn't confer a benefit directly on Altenex Massachusetts, and that is not a requirement of unjust enrichment. What Altenex has done is it's conflated the concept of quantum merit, which is a specific species of unjust enrichment, with unjust enrichment generally. And there is a particular case cited in my brief, the Malonis case, where this point is illustrated, where an attorney represented a client, did all this work, then was terminated. It was a contingency fee agreement. And then the client brought in a new attorney who then settled the case and got the entire contingency fee. The first attorney had a claim directly against the second attorney for unjust enrichment because he received all of the contingency fee money when the original attorney had done most of the work. He never provided services to the second attorney. That's exactly the situation we have here, where Mr. Petrucci did things to MMS, and then MMS transferred its assets to Altenex Massachusetts, and Altenex Massachusetts was enriched by having these assets that it knew were illicitly obtained from Mr. Petrucci without compensating him.
Well, your time is up. 15 minutes can go by very quickly sometimes, but I'm going to double check with the panel to see if they have any specific follow-up questions for you. And I'm not seeing any from either one of my colleagues. All right, so thank you very much for your argument. We'll turn now to Attorney Doherty, and you will have 10 minutes.
Good morning, Your Honors, and may it please the court. I'm Adam Doherty, and I represent the appellees and cross-appellants Charles Esdale and Christopher Hayes. I'll split my time this morning with Mr. Solomon, who represents the other appellees, cross-appellants Duncan McIntyre and Altenex LLC. I'll take 10 minutes to address arguments concerning the individual defendants, including Mr. McIntyre, and Mr. Solomon will use the remaining 5 to address arguments concerning Altenex LLC. Subject to Your Honor's questions this morning, there are 2 issues that I'd like to address that will largely respond to the points that Ms. Kennedy just made. The first is this argument that the trial court erred by awarding Mr. Petrucci rescissory damages based on his proportionate share of the value of the assets that were transferred from MMS to Altenex, Massachusetts at the time of the dissolution of MMS in July 2011, instead of awarding Mr. Petrucci damages based on a fiction that Mr. Petrucci should be treated as owning 30% of Altenex Mass, and that the damages should be judged by the value, his 30% share of a company that he never owned 5 years later when it was sold for a substantial amount of money. And then I will turn to the statute of limitations and the error Judge Salinger made by applying the 6-year Massachusetts limitations period to Mr. Petrucci's breach of contract claim, instead of honoring the Delaware choice of law provision in section 10.4 of the MMS operating agreement, which requires that the 3-year Delaware statute of limitations be applied. And that's an important issue because if the individual defendants prevail, Mr. Petrucci's own trial testimony establishes that he knew when he received the $300 check that the individual defendants had breached. And therefore his breach of contract claim and all his other claims are barred by the statute of limitations, and it will resolve this entire appeal.
I thought I heard Attorney Kennedy quarrel with the way that they determined the value of Altenex Mass in July of 2011. Is that not what I heard?
The individual defendants were found by Judge Salinger to have undervalued the assets. That's the only breach that Judge Salinger found, was a breach of section 7.3 and not paying Mr. Petrucci an amount equivalent to his proportionate share. I think what Ms. Kennedy said was that Judge Salinger inappropriately considered future events when he determined what the value of those assets were in July 2011. That is just factually incorrect. Judge Salinger did not consider future events when he determined what the value was in July 2011. He only looked at future events after determining what the value was in 2011 to determine whether there was later a higher value, because that's what rescissory damages allows under Delaware law. And we don't agree that rescissory damages were appropriate, but Delaware law allows you to look at future events to determine whether they had a higher value later. What Judge Salinger did was he adopted the plaintiff's expert's opinion with one exception. He did not agree that the assets transferred were equal to the entire value of Altenex Massachusetts, $8 million. He looked at the specific assets that were transferred, the Altenex name, the Altenex trademark, the Dow contract, certain network participant agreements, and the goodwill that Altenex Delaware had. And what he determined was that those specific assets, using the same projected cash flows that the plaintiff's expert used, the only revenue generating asset at that time was this Dow contract. And it's important to note that the Dow contract concerned one Dow facility, and that's the MyOps project in Michigan. If the individual defendants were successful at Altenex Massachusetts in fulfilling that contract and matching Dow with one of the network participants to supply renewable energy to that facility, they would have been paid one lump sum. And the evidence showed that they expected to be paid that lump sum in 2012. and that they expected to be paid $1.9 million. What Judge Salinger found was that those assets, when they're put together, and based on the projected revenues, the reasonable expectation in 2011, when the assets were transferred, were that those assets would generate 1.9 million in 2012. He then decreased that amount by the expenses that were expected in 2012 to get to an amount of 1.6 million for the value of those assets. He then applied Mr. Petrucci's plaintiff's expert's opinion that a 60% discount should apply to come to a value of 1 million, and he awarded Mr. Petrucci 300,000. What he found was that after, and this is well supported by the evidence, that after 2012, any additional revenues that were projected would have been derived from additional work by those, by the individual defendants, employees that they hired, and different contracts with different companies. What he found in the way he determined that they had their highest value was exactly what Justice Vuono had raised, that they invented the REPA after. They never made a dime off of the advisory, what Mr. Petrucci calls the advisory and procurement business. They realized that that would not work. So they pivoted and they literally invented the REPA, which is now industry standard. That is what caused the value of the company to skyrocket, and that's why they were sold. So that's Judge Salinger's opinion or findings of fact with respect to the value are well supported by the evidence, and he did not make any error. Now, I'm running low on time. If I could just address Ms. Kennedy's argument about Section 415. What Ms. Kennedy did was isolate Section 415 and say, well, this doesn't allow the individual defendants to transfer the assets and to operate the same type of business. That's exactly what Section 415 allows. And when read with the other provisions of the contract, Section 7.1 allowed the individual defendants to dissolve MMS. Section 7.2 allowed them to make in-kind distributions to Altenex, Massachusetts. And 7.3 laid out what they had to do. The only in determining the fair market value, the only breach was that they didn't pay him enough money under 7.3. And all the findings that Ms. Kennedy referred to at the beginning of her argument go to how they determined the fair market value. It goes to the only breach that was found. When you read all of those provisions together, the individual defendants were authorized, contractually authorized to do every single thing they did other than pay Mr. Petrucci $300. And what Ms. Kennedy is asking this court to do is to disregard the express provisions of Section 415 and the other express provisions of the contract to apply some kind of free-floating implied covenant. And that's exactly what Delaware courts do not permit. In Delaware, the implied covenant is very, very narrow, much more narrow than in Massachusetts. And what the court says is that if there is conduct that is addressed by the contract, their fairness doesn't matter. You look at the contract, if it addresses the conduct, either the conduct breached the provision or it did not. You have a breach of contract. And Ms. Kennedy's reference to the Gerber decision. The Gerber decision involved a situation where the majority shareholder could get a fairness opinion. And if he relied on a fairness opinion, he was exculpated from any liability. The court did not find that getting the fairness opinion was a violation. The court found that because he went and got a fairness opinion that literally did not opine on the price that was paid to the minority unit holders, that breached the implied covenant. And the court implied the entire fairness standard into the in that situation. Here, there was no need to imply the entire fairness standard because Judge Salinger found that under sections 411 and section 7.3, the entire fairness standard was written in. So that the only place that there was any discretion by the individual defendants was setting that price, and the court found that the contract, there was no gap. The contract had already addressed the standard by which that discretion needs to be exercised. And I'm running very low on time. So I just want to quickly address the statute of limitations. If your honors read the Gordeau decision, the SJC did not hold that section 142 applies even if there's a choice of law provision. The choice of law provision in that case, which was found in a form contract, was waived. The court specifically states that it was waived. Mr. Petrucci's mistake is relying on that case. Judge Salinger's mistake is relying on Shamrock Realty, which also did not include a choice of law provision. I would urge the court to look at Judge Woodlock's reasoning in the Shimizu case, where he got it exactly right.
Thank you very much. But before that you conclude, I'm just going to double check with the panel to be sure they didn't have any follow-up questions specifically for you. And I'm seeing none. So I'm seeing none. Okay, so we're going to turn now to Attorney Solomont for your 5 minutes. Up, you're on mute. Happens all the time.
Apologies.
That's okay.
Thank you. May it please the court. As you noted, I'm Charles Solomont, and with Emma Hall, who's watching from on Zoom. We represent 3 individual defendants. We represent one of the 3 individual defendants, Duncan McIntyre. We also represent defendant Altenex, Massachusetts. And subject to Your Honor's questions, I'm going to focus on the plaintiff's appeal of the dismissal of his 93A claim against Altenex, Massachusetts, which Ms. Kennedy referenced. I note that that Mr. Petrucci, the plaintiff, filed a notice of supplemental authority, and the notice said that the SJC's recent decision in Governo Law Firm versus Bergeron relates to his 93A claim against Altenex. Governo, in fact, reinforces that the 93A claim was properly dismissed. In Governo, several lawyers, while they were employed by a law firm, stole the firm's intellectual property and then left the firm and used it to compete. The SJC held that the illegal conduct of the employees while they were employed was relevant to whether their use of the stolen assets after they left the firm violated 93A. In this case, irrespective of what the individual defendants did prior to the transfer of the assets from Market Maker Solutions to Altenex, Massachusetts, the plaintiff's operative complaint, the second amended complaint, failed to state a viable 93A claim for 3 main reasons. First, the plaintiff lacks standing to sue under 93A. Second, he alleges no unfair competition. Unfair competition is required for a 93A claim, whereas here, the plaintiff, Mr. Petrucci, and the defendant, Altenex, Massachusetts, never engaged in business with one another. This case, in fact, involves no competition. It is a purely intra-enterprise dispute about whether or not the plaintiff got what he was entitled to under his operating agreement with the defendants. And the third reason why the 93A claim can't stand is that Altenex, Massachusetts was the assignee of the assets. Nothing it did is alleged to have caused the plaintiff a substantial injury, which is another missing essential element of his 93A claim. So as to lack of standing, Your Honors, the transferred assets did not belong to Mr. Petrucci. They belonged to Market Maker Solutions, the LLC. He merely owned a 30% piece of MMS. In Governo, the law firm that owned the stolen assets was the plaintiff. So to maintain a 93A claim, a plaintiff has to have engaged in the conduct of trade or commerce. Again, Mr. Petrucci was just a member of MMS, the assets of which were transferred to Altenex. Owning membership interests in an LLC is not trade or commerce. It doesn't meet the standing requirement of 93A. So while the plaintiff might theoretically have had a derivative claim on behalf of MMS against Altenex, Massachusetts, he has no individual claim. The plaintiff's complaint also doesn't state a 93A claim because it doesn't allege unfair competition. The defendants in Governo were only subject to 93A because using stolen property to compete implicated the unfair competition prong of Section 11. Section 11 isn't implicated in this case because there's no plausible allegation that Altenex, Massachusetts competed with Mr. Petrucci. Again, the assets belong to MMS, not to the plaintiff. And importantly, MMS dissolved before its assets were transferred to Altenex, Massachusetts. So Altenex, Massachusetts never competed with MMS, never mind Petrucci individually. Again, as the trial court found, this is a private intra-company breach of contract case. The plaintiff and the individual defendants were members of MMS, and the case just dissolved to whether or not Mr. Petrucci received his fair share of the value of MMS's assets upon MMS's dissolution as the MMS operating agreement required. That epitomizes an intra-company dispute. Plaintiffs.
What about you also argued that there's no unjust enrichment claim, but isn't there an unjust enrichment when the corporation ends up basically taking assets stolen from him?
Well, I mean, as a matter of law, no, Your Honor. I mean, under Chang, which the appeals court's case from last year, where unjust enrichment, you get the value of what you have added. This claim is not based upon that. As in Chang, the plaintiff bases his interest purely on a percentage interest that he claims to have had in another company. Chang very clearly holds that a plaintiff cannot maintain an unjust enrichment claim that is based upon his or her percentage interest in a venture created by a contract. Because again, an unjust enrichment claim can't stand in the face of an express contract. I see my time is up.
5 minutes goes even faster than 15. So that's so your time is up. But I'm going to check to see if the panel has any additional questions they'd like to pose to you before we sign off. I see none. Or maybe just
short of giving everybody another half an hour. I don't think so.
Yeah. Well, thank you all very much for your arguments. Thank you very much for your detailed briefs. They were very helpful. It certainly is a complicated case, but we'll take it under advisement and we'll get back to you as soon as.
We are live.
Okay, thank you very much, and good afternoon, and welcome to this afternoon's remote sitting of the appeals court. Let me introduce the panel to you. My name is Ariane Vuono, and I'm joined today by Justice Gregory Massing and Justice Kenneth Desmond. Two quick reminders that I think you all know, because I think I recognize all of you that are here to argue today. Each side has 15 minutes, and I understand that both sides have split time. Attorney Krasner will have 10 minutes, and Attorney Kilkelly 5 minutes. Am I correct? Okay. Attorney Jaspers will also have 8 minutes, and Attorney Dow 7 minutes. And as our clerk already indicated, that will be reflected in the timer. If we have any technical difficulties, we usually can resolve them fairly quickly, and I can assure you that we won't, nobody will lose any of their time. With all that preamble said, I'm going to call the case. It's Department of Children and Families versus Father and Others, 2020-0900. Attorney Krasner, you will be the first. We'll hear from you first.
Thank you. Good afternoon. May it please the court. Sherry Krasner. I represent the father. My client, as you know, knowingly ceded his parental rights in this case, but as part of that agreement, he was allowed to participate in the dispositional phase of the case and to appeal any adverse decision, and that is what he is doing here. By being an appellant and by supporting his mother as the proposed adoptive resource for the child, so it's not a backdoor attempt to cross any boundaries. He understood that the grandmother would be the mother of the child and she would control any access that he had to the child. The judge in her findings seems to suggest that grandmother would not be able to maintain those boundaries. But the only evidence, and I underscore the only evidence of that, came from the foster mother, who purportedly said that the child had reported to her that he had seen his father when he was having his 5.5-hour unsupervised visits with the grandmother. When that evidence first came, or that report first came to light, the adoption social worker actually started transporting the child to see if there was any evidence that supported that. She did not observe any. She also went into the home, no evidence that father was living there. There also was a family resource worker who worked with the family, with the grandmother, came into the house for both announced and unannounced visits and never saw the father in the home. Now, this all goes to credibility of the foster mother. I completely understand, my client understands that this court defers to the assessments made by a trial judge in a case. She's the one who sees the witnesses, hears them, reviews the evidence. But to defer to her, she has to do something that merits that deference. And I would suggest that that did not occur in this case. The judge simply did not review all of the evidence that was before her in this case. Again, I'm not talking about reviewing it and discrediting it, reviewing it and not giving it ample weight or the weight that we would like to see her give to it. We're talking about a trial judge that did not fully and meaningfully evaluate the evidence that was before her. For this judge, as she does in finding 61, to say that the foster mother was rejected back in 2005 when she applied to become a foster mother, that she was rejected because there were some concerns, clearly indicates that the judge did not actually thoroughly and fully evaluate that piece of documentary evidence that this court can now review.
Did you at the trial, did you actually put that piece of, actively put that piece of documentary evidence in front of the judge and say, Judge, look at this?
I was not trial counsel.
Did your predecessor?
But the evidence, it was introduced as an exhibit at trial. There's no dispute.
I mean, there were several things were introduced as exhibits, but did the specific import of that particular document, was that brought to the judge's attention?
Well, the foster mother was questioned about whether or not, about the reasons why she didn't get accepted back in 2005. And she claimed that she had no recollection of why she hadn't been rejected back in 2005. So she was questioned about.
So then the comeback would be, well, can I draw your attention to this document? Didn't you say in 2005? But that didn't happen.
That did not happen. But again, it was offered into evidence. It wasn't, nothing was redacted from it. And the judge, to do a comprehensive and full review of the evidence does not only mean listening to the testimony, it means looking at the documents. These are very document heavy cases.
If the judge if there was a similar document about your client and the judge was deciding on unfitness of your client, there was something that he did in 2005, wouldn't you be saying the judge can't rely on that because it's stale?
If that was the only problem, but that wasn't the only problem here. The foster mother was then reapplied to be a foster mother in 2015, and then did a evaluation child specific to adopt this child in 2018. And the trial in this matter started in 2019. And in those documents in 2015 and in those documents in 2018, there's no other way to say it than she lied. She indicated that she had put on hold the application back in 2005. She indicated that she had never had issues with infertility, and yet the supposed infertility was a major reason in 2005 why she came forward and wanted to adopt, or wanted to be a foster parent, strike that. So again, yes, the argument certainly could be made, she's grown over these past 14 years and we need to put that evidence in perspective. But the problem here is that she perpetuated the falsehood, and the bigger problem is that the trial judge failed to look at that evidence in doing an even-handed assessment. So again, it's not the judge saying, okay, I've considered that, there's been that growth, she was different back then. The judge simply said, oh, there were some concerns in 2005, and she didn't pay the requisite attention that these kinds of cases, competing adoption plan cases, deserve. So that's the problem here.
So since that time, foster mom has fostered 37 babies, right?
There are many children she's had in her home. Yes.
And many had medical challenges. And she's
Yes.
done all of that essentially without incident.
That the evidence suggests that she provided good care, including to the subject child here. That's not the issue in dispute. We don't say that that wasn't true. It is, however, when the judge makes a blanket statement that DCF has had no concerns with this foster parent, that wasn't completely supported by the evidence. There was a time in 2017 where there was a suggestion that the foster mother might be overwhelmed, and the foster mother herself had expressed some feelings of being overwhelmed. The specific record sites are in my brief. There also the same family resource worker who made both announced and unannounced visits to the home also said that in her office, people didn't place children with this mother, this foster mother. So yes, she provided good care. And yes, she provided good care to this child, but that wasn't the only issue that was before the judge in evaluating the competing plans.
And the child supports the foster mom.
At trial, the child's position and now is with the foster mother. Yes, that is correct. But again, that doesn't address the issue of whether the judge did a fair and meaningful evaluation of the evidence that was before her. And I know my brother will address this, but I also just want to mention the undue weight that was given to the decision of the fair hearing officer. That the fair hearing officer had a narrow issue before her, and it had to do with the removal of the child, the circumstances under which the child who had lived in her home for 3.5 years was being removed. And she was the appellant. She was the party who was alleging in a one-sided proceeding in which grandmother had no regulatory right to participate, but she was alleging that the foster mother, that the way that the child was being removed from her home was contrary to department regulations. And the fair hearing officer indicated that it was, but in so indicating, the fair hearing officer wasn't saying that this makes this the parent who should be adopting the child, or this elevates this foster parent above the kin placement. She was just addressing that very narrow regulatory issue of how it was proposed to remove the child from the home. And the judge's failure at trial to see that in its proper perspective is also error. And the judge said, I believe it is finding, forgive me for this, don't have the exact finding in front of me, but the judge indicated that the child was being removed because of the decision of the fair hearing officer. And that's not exactly what's supported by the evidence. And I see my time.
I want to ask a question. I want to ask a question based on in the child's brief. The child argues that if you were unhappy with the fair decision, that you were supposed to file an abuse of discretion motion. How do you respond to that?
The trial was going on. It is true, no such motion was filed, but also when the trial began, the department changed its position on that very first day of trial. They hadn't even seen what the decision said. And certainly the father and grandmother hadn't seen that decision. And by the time the decision was available, it was already near the conclusion of trial. So I think to come forward with that motion when the trial was nearing its conclusion would not have been an appropriate thing to do. It was now a trial about the two competing plans, and that was the decision that was before the judge. But for the judge not to consider how that decision came about and what the narrow import of that decision was, I would.
Okay, I'm sorry, and I just got one more question. I don't know if you know the answer. There is testimony about the clinical review team in July 2018 making a decision to making this decision that got later challenged at the fair hearing. Do we have that July 2018? There's a summary report by the area program manager. Is that in the record?
That's an internal meeting, so that document wasn't addressed, but in the fair hearing decision, and I believe it's somewhere between pages 84 and 88, they list what was discussed, or how the area clinical team came to determine that grandmother was the appropriate
okay, good.
the
Thank
placement
you.
that would serve the child's best interest.
Thank you. That's all.
Thank you.
Okay. Thank you very much. We'll turn now to Attorney, excuse me, Kilkelly.
I'm just waiting for my time. There it goes. Thank you. May it please the court, my name is Michael Kilkelly and I represent the grandmother in this appeal. And the grandmother is appealing the decision of the trial court to choose the foster mother for the adoptive resource rather than the grandmother. And I wanted to pick up first on the fair hearing issue because the grandmother had no say in the fair hearing, had no role in the fair hearing, was not present at the fair hearing, and had no ability to challenge the fair hearing, and didn't know what the reason or what the basis or what the actual written decision of the fair hearing was until well into this trial. And I would support Attorney Krasner's position that there was no opportunity for an abuse of discretion motion, because the only decision the fair hearing officer made is that the transition plan from the foster mother to the grandmother had not been thought out completely and didn't follow the department's regulations. And so if the trial court had decided that the grandmother would adopt, the answer was for the department to come up with a better transition plan than they had. And so that would have been the end result. I did want to speak in my limited time to the grandmother. I think the trial court did not properly credit the background of the grandmother, her training and experience as a licensed foster parent herself. She herself went through all of the foster parent training. She had a medically needy foster child placed in her home by DCF at the time of trial. She also had familiarized herself completely with the medical needs of her grandson. She had been to all of his medical appointments. She had reviewed all of his records, learned about his medical needs.
On that point, why didn't the grandmother want to talk to the foster mom about the child's SVT diagnosis? I think I read in the brief that she didn't want to discuss with the foster mom the care that the foster mom was providing to the child about that particular condition.
I think the grandmother just wanted to go directly to the cardiologist, to the cardiac nurses, and learn all about it that way. And she did. She met with the nurses. She was instructed on how to take care of the child, and she just and I think grandmother was concerned about the way foster mother was taking care of the child. And there was testimony at the trial that the foster mother, on at least one occasion, if not two occasions, totally missed an SVT episode that the child was undergoing. And so the grandmother didn't think the foster mother was particularly doing a good job in that respect, and wanted to get accurate information from the experts, from the cardiologist and from the cardiac nurse, and did that. I also briefly wanted to address an argument the appellees made, which is that the foster family is the only family that this child has known. And in fact, that's not accurate, because the child has known his biological family, has known his grandmother since he was 6 months old. His visits with his father took place at grandmother's house. He has his own room at grandmother's house, his own bedroom there, which he is very familiar with. even though the main visits initially were with the father, the grandmother was there, the visits were taking place at her house. And when she stepped forward as an adoptive resource, after the father stepped back, she took over and has a very close attachment with her grandson, as the evidence showed. She had very extensive unsupervised visits with him, which took place partly at her house. And so we would contend that the trial court decision is not in the child's best interest, and that in fact adoption by his grandmother would further his connection to his family, to his biological family, to all of his aunts and uncles and cousins, and to his biological family culture, and that in fact adoption by his grandmother would be in his best interest. Thank you very much.
I'm going to just check with the panel, see if they have any follow-up questions for you. And I don't see that we do. All right, so thank you very much, Attorney Kilkelly, for your argument. We'll move now to the attorney for the Department of Children and Families, Attorney Jaspers. You have 8 minutes.
Thank you. May it please the court, Adelaida Jaspers for the appellee, the Department of Children and Families. Contrary to the appellant's claims, who merely disagree with the judge's weighing of the evidence, which is squarely within her discretion, here, the judge even-handedly considered the evidence regarding the competing plans and properly determined that the plan of adoption of the child by the foster mother, a plan which the child supports, served his best interest for the following reasons. The child is now 6 years old and has been in the care of the foster mother since he was an infant. The foster mother has successfully cared for him and attended to his complex medical needs since his infancy. He has thrived in her care, and separation from her would result in disrupting this medically complex child's secure attachment and likely lead to harmful effects for him. All these factors, when weighed against the evidence that the grandmother had been unable to set sufficient boundaries with the father, and that she lacked the appreciation for the harm that would likely follow from severing the child's primary relationship, and that she did not become meaningfully involved with the child until he was 2 years old, tipped the balance toward the conclusion that the plan of adoption by the foster mother serves the child's best interest.
Can I ask you? Go ahead, Judge. Oh no, after you. I'll go ahead. Two questions for you. If this was a termination of parental rights case, that we wouldn't. It'll be difficult to consider. We couldn't just consider that the child's been 6 years with the foster mom, therefore he shouldn't go back to his parents. But when we're talking about a placement between a grandmother and a foster mother, can we consider that more fully?
Yes, Your Honor. The attachment of the child with a substitute caretaker is one of the factors that the court should consider, and the court considered in this case.
You don't have to. I think it's adoption of Catherine says you have to make particular findings when that's a major factor in terminating parental rights. But that doesn't apply in this setting, does it?
Your Honor, the adoption of Catherine relates to the severance, the trauma that ensues after the severance of the relationship or the bond, and it applies to a biological parent. In this context, in my brief, I cite to a case, I think it's guardianship of ESDAILE, and the name might be mistaken, but it is in my brief that the court can consider the attachment and the bond that has been formed between the child and the substitute caregiver, in this case, the foster mother.
One more question, and then that'll be Judge Desmond's turn. When the fair hearing determines that DCF made an error in the way it made its change of plan, or decided to make the grandmother the adoptive resource, is DCF as a administrative error then stuck? They have to now support the foster mother. Is that right?
Well, in a way, but I'd like to explain it a little more thoroughly.
Please do.
The fair hearing decision is subject to the commissioner's review, which in this case occurred, and that is a 21-day period. So this fair hearing decision was vetted internally, Your Honor. Therefore, once the determination is made by the commissioner, that decision is binding upon the department. I don't know if that explains.
So then the department can't advocate for the grandmother.
You're correct, Your Honor. After that became final, the department is bound by the fair hearing decision. But ultimately, in regard to that, my brother and sister argue that the court erred in not paying enough adequate attention to the decision of the department regarding which plan is proposed. But what matters here is that the judge even-handedly weighed each plan and chose the one that was in the best interest of the child, which was the plan of adoption by the foster mother. The judge was not constrained by the department's permanency plan or the fair hearing decision before concluding that that plan best served the child's interest in this case, and the evidence supported that.
So
I'm going to interrupt. Justice Desmond had a question here.
Just to be clear, so the department had to support the fair hearing decision, whether they agreed with it or not. That's what I think I heard you just say to Judge Massing, right?
Well, sorry if that is what I did not mean to say, whether agreed or not, but what I should clarify here is that that decision was vetted internally, and that was the proper decision. So where the department made the initial decision in 2018, that decision elevated the biological connection between the grandmother and the child. And the fair hearing decision highlighted that that was not the sole factor, that the decision should have also taken into consideration the individual needs of the child, namely the impact of trauma from separation, and also the concern about the grandmother facing adequate boundaries with the father. So in that case, the department, that decision highlighted the error, and the department cured that error by moving forward.
I heard counsel for the grandmother say that the biological grandmother, the family's culture, was a factor that was not considered adequately or not considered at all. Was that considered by the
court? Certainly considered the biological ties, Your Honor, in this case. But placement decisions must be solely in the best interest of the child, and that requires a multifactorial analysis which takes into consideration the individual needs of the child and also the capacity of the caregiver or prospective caregiver to care for the child. So while biological ties are desirable, they are not. That is one factor among many. And the court here could not elevate that over.
And was the culture of the biological family considered specifically?
There was no evidence provided as to related to the culture of the biological family in this case. That's nothing in the record regarding that. But nonetheless, the court did consider finding 80 and conclusion of law 3. And then again, the court here could not allow the biological ties to dictate the placement decision when it was not consistent with the child's best interest. And for the following reasons, there were concerns about the grandmother here, which I alluded to earlier. So one of them was that she was unable to set adequate boundaries with the father. She couldn't say where the father resided, but she did not. She admitted at trial that he used her address as her primary address. And I see that my time has expired. If I could conclude by saying that the child deserves permanency and stability, which this plan would provide, and that he has been in this family since infancy when he was detoxing as a preterm infant, and he is a medically complex child, and severance of the trauma given his conditions is very, very concerning in this case. Therefore, this court should affirm the decision of the trial court. If there are no questions, I'd like to rest on my brief.
Right, I'm just going to check with the panel to see if there's any follow-up questions with respect to your position. I see none. Okay, we'll turn now to hear from counsel for the child, Attorney Dow.
Thank you, Your Honor. The I just want to start out by saying that it seems as if father and grandmother in this case are almost trying to assign blame to the judge for having to go through this process of evaluating in an even-handed manner the competing plans. And to some extent, the hearing officer's decision can be considered at least minimally a red herring. The judge has to consider the plans that are before the judge. Those plans can come from everybody. So even if DCF had not brought forward a plan regarding the foster mother, the child certainly could have done so. So this isn't solely on DCF to bring forward this plan or to propose the foster mother. The child has supported this position throughout the proceedings. The findings, I think, are very detailed in this case. There are 116 findings, and the judge clearly looked at the evidence. There were 17 witnesses, including one expert, and I think 22 exhibits that the judge was able to go through. And I think with respect to Attorney Krasner's argument that there was no consideration for the fact that the judge really didn't look strongly at the issue of whether the grandmother was able to separate herself from the father, the judge really did look at that. I believe it was in conclusion number 5 that the judge went through a whole paragraph, a whole litany of what her concerns were, what her continuing concerns were with respect to the grandmother and the grandmother's continuing relationship with a father who had not only stipulated to the termination of his parental rights, but who we all know, and I think it's undisputed, that he had longstanding drug issues. And the drug issues continued throughout the pendency of this case. And the judge clearly expressed her concern that the grandmother would not be able to separate herself. And it was one of the considerations that she made, not the sole consideration, but one of the considerations that the judge took into account in making a determination as to the overall best interests of this child and where this child should reside. So I think with respect to the findings, I think those findings were very detailed. She definitely gave consideration to the positives of the grandmother and the positive attributes. She talked about the grandmother going through the foster care training. She talked about the fact that the grandmother did have, for a period of time, a medically compromised child in her home. So those facts were not disregarded. But what she did do, what the judge did do appropriately, was to talk about and make a decision based on a global look at where this child should be living and who he should be living with permanently. And excuse me, and in doing so, she took into consideration the issues of safety. She took into consideration the fact that this child had a bond with the foster family, the foster mother and the foster siblings. And that bond was testified to and described by an expert. The grandmother could have had her own expert. The father could have hired an expert with respect to the grandmother and did not do so. So we have that undisputed testimony of Dr. Spetter saying that there is a bond and that this child has a significant bond because this is the only family that he has ever resided with. Excuse me. I think the other piece is that
I'm sorry, I'm going to interrupt. The judge finds there's this episode of a couple of SVT episodes when they're trying to wean the child off the medicine, and the doctor sort of scold the foster mother for not having called them directly, but yet the judge goes on to find that the department has no concerns about that. Are those inconsistent?
Well, interestingly, the social worker did testify to that. The social worker, the ongoing worker did testify that the department had no concerns with respect to the foster mother and her ability to manage or monitor the SVT incidents. Additionally, the cardiologist who testified that with respect to the second incident, there was nothing that the foster mother did that would have been done differently in the ER. And I think that was made or rendered as part of the judge's findings.
Was that the Pennsylvania episode? Was that the Pennsylvania episode?
Yes, it was, Your Honor.
Okay.
Yes, and that was where I believe she used ice and massage to, try to alleviate the SVT incident that occurred during that time. So I don't believe that in the end that those were, that is inconsistent, just given the fact that we have testimony of the cardiologist and the social worker.
Was there some question about foster mom's credibility on that issue, about how long the episode lasted?
And again, I think there definitely was some conflicting testimony. The social worker, the ongoing worker, testified she believed the incidents lasted somewhere between half an hour and 45 minutes. And the foster mother testified that they were, I believe, under approximately 5 minutes, not of significant length and time. So I don't know that the judge rendered a finding specifically as to the credibility of one over the other, but did address both of those, the foster mother's version versus the social worker's version in her findings. So in conclusion, I would just rest on my brief and ask that the trial judge's decision be upheld. Thank you.
Okay, thank you. I'm just going to check to see if the panel has any follow-up questions for you. I see none. I thank you all, four of you, for your arguments and your briefs. We know how difficult these cases are. This case poses particularly challenging issues, so we appreciate your helping us out with your arguments.
Very well presented by everybody.
Yep. So we appreciate it, and we'll look at everything you've submitted to us and consider your arguments.
Yeah, thank you. Yeah, thank you. Okay.
All right, we're live.
Okay, so now we're live. So one moment, Ms. STOTSKY-HILMAN, one moment, and I'm going to begin by introducing the panel. I've already introduced myself to you. My name is Justice Vuono.
Okay, so now we're live.
I'm hearing a little bit of feedback from you, so I see you're off.
So
okay.
I've muted Ms. STOTSKY-HILMAN. It sounds like you have the YouTube open, so we're getting some feedback. If you could please just mute your YouTube window or mute your computer, that would help with the issue.
We don't know because she's on mute.
Well, now we don't know because she's on mute. And Ms. STOTSKY-HILMAN, I've muted you, but I've asked you to unmute. So if you could please.
Why don't you bring her back, Angela, and we can see if we can speak with her.
Okay. I'm going to end the recording and the stream.
No.
Okay, and we're live again.
Okay, thank you very much. So good afternoon. We've had a few technical difficulties, but they seem to be resolved. I'm going to introduce the panel and then call the case. My name is Ariane Vuono. I'm joined today by Justice Gregory Massing and Justice Kenneth Desmond. We have Ms. Sharon STOTSKY-HILMAN appearing via telephone. So I guess you're not really appearing, but you're participating via telephone today. And also Attorney Bernards, who is here on video. The name of our last case today is Sharon STOTSKY-HILMAN versus Eric Hillman, 2020-0956. Ms. STOTSKY-HILMAN, you will be arguing first, and you have 15 minutes to present your argument. You can be assured that we review the entire record carefully And so we urge you to get right to your most important points. And after you're finished, and I will actually give you a warning when you only have 5 minutes left, we will hear from Attorney Bernards, and there is no rebuttal. So once you finish your argument, please stay on and listen, but you are no longer permitted to say anything to us, okay?
Okay.
All right, so you can start right now.
Okay. I am SHARON STOTSKY-HILMAN, the appellant. May it please the court. This is a post-divorce equity complaint that was dismissed by the family court judge without any findings or rationale for the dismissal. The case set out substantial wrongdoing by my former spouse that was discovered post-divorce. And apart from this case, I do not have any remedy to rectify this. It's a 7-figure settlement involving 24 employees, 10,000 patients, in addition to myself, for my primary care, internal medicine, and arthritis practice. As a threshold matter—
I'm going to just interrupt you for a moment and ask you, because it seems to me the main issue before us is how the judge dealt with the delay between the time that you filed this complaint, which is about a year or so after the judgment entered on the divorce, if I'm not mistaken, and then let 6 years or so pass before anything happened. So the judge decided, as you know, that there was not a good basis for that. Do you want to address that?
Yes, the threshold matter is I'd like to address the timing of the filing. The judgment was docketed December 12th, 2011, not December 1st as represented by opposing counsel. And my motion was filed on December 12th, 2012. And the statute says that the motion must be filed not more than 1 year, and therefore it was. If there's any dispute about this, I have Attorney Willett, BBO 544-522's billing records and emails indicating that the motion was filed on December 11th, and it was FedExed as well. I will ask leave of the court to file both of these documents if there's any further dispute as to whether or not the document was, whether or not the complaint was timely.
Let me explain something to you, and that is we cannot review any documents that were not before the judge in the probate and family court. Okay, so if those documents were not before that judge, we're not permitted to review them. That judge has to review them in the first instance. But be that as it may, there was no appeal filed in the underlying case. Your complaint in equity was filed, we'll just say for argument's sake, a year later. But then, of course, there was the subsequent delay. That was what was the focus of the judge's decision. What do you have to say about that?
Okay. All right. The next point was if we rely upon the docket of the complaint, the docket shows that the other side never filed a timely answer, an answer, even an appearance. So if we are looking at the docket, that's what we have for the other side. And I should have been allowed to amend my complaint under Rule 15 in Family Court, Rule 408. The delay in timing is Attorney Willett retained the complaint until the summer of 2019 and did not move forward with it. So I was unable to do much with it until then, until I was notified.
I have a question about that. I did see that you alleged that that you wanted to appeal and that the attorney did not follow your instructions, and I'm going to quote, I think, something you said about dropping the ball, but apparently you resolved that with her. There was a lawsuit and there was a settlement.
No, that was with Tom Carey. Again, they were supposed to write my appeal, and they had not been able to get that done. There was a lawsuit that was found in my favor, but the discussion was not withdrawing my appeal. The discussion was voiding the promissory note so that there would be no need to have an appeal. And that was not what they discussed with the other side, which was therefore the cause for their legal malpractice suit that was settled in my favor. But I did not voluntarily
I just want to be clear that I understand this, because one of the issues here is whether or not the arguments that you make in your complaint for equity and in your amended complaint that wasn't allowed, but you say should have been, were they arguments that should have been made in a direct appeal? And you say that you want to appeal, the attorney did not appeal, but that resolved itself. In other words, there was a lawsuit that was decided in your favor with respect to that issue. Am I correct?
I was not made whole with the resolution of the lawsuit, but yes, it was resolved in my favor, but I was not made whole.
Okay. All right. Okay. You can continue.
Okay. The other point was that the motion in front of Judge Bezenius was confounded into a summary judgment by the opposition and did not give me the opportunity to conduct proper discovery. They had brought in additional information and documents outside of the complaint that I could not respond to or conduct discovery, and could only respond with oral argument that I did not have sufficient time to prepare for. Mr. Hillman has not been prejudiced.
Wait, hold on. Could you just be a little more specific? What was presented that you felt that you did not have a sufficient time to review? What particular documents are you referring to?
Whether or not the motion was timely filed, that was the major document. And they didn't give me the documents afterwards, so I don't have them.
All right. And this is something that you think that the judge relied on in rendering her decision?
I don't know, because the judge did not have any findings, any written findings, or any rationale for her dismissal.
Dr. STOTSKY-HILMAN, this is Judge Massing. I've got a couple of questions. So I understand you're trying. You have a dispute about the assets based on, you say that the ex-husband withheld some financial documents. They say that those were disclosed. You also say that there was some misconduct about the valuation. What new evidence? And this is your amended complaint. What new evidence about the valuation do you have?
Okay, there's what is known within a year of the judgment being entered, which was some manipulation of the numbers plugged into the equation by the Harvard Business School educated former husband. And then there's what was learned when I went to the granddaddy of healthcare consultants, the one who taught everybody else how to value a physician's practice. I called the IRS. I spoke to a former agent, Mike Gregory, and he told me the best business valuation person for medical practices, the ones who wrote the book, was Health Capital Consultants out of St. Louis. And I had them prepare a valuation for my business using the same parameters. And they discovered that they had, Mr. Hillman's and his attorney and his business valuation expert had played with the numbers in a way to maximize the take that was inconsistent with how the judge had asked the valuation to be done. I can be more specific if you like.
So it seems to me that if whoever was representing you at the divorce had been more on the ball, they could have discovered it during the divorce litigation.
This was very difficult to discover, but basically the judge had asked for a 12-month period, and Mr. Hillman's attorneys had used the numbers from a different period to overstate the cash flow to capitalize.
Didn't you have your own valuation expert? I'm sorry. Didn't you have your own valuation expert at trial?
He didn't figure it out either. Health Capital Consultants figured it out, and it took them a while to figure it out too.
Okay. But
it was very carefully done.
But your valuation expert obviously didn't agree with Mr. Hillman's valuation expert, right?
Yeah, neither valuation expert, the one that was for trial, and Health Capital Consultants certainly didn't agree. And the numbers Health Capital Consultant came up with were consistent with similar practices to mine. There was half a dozen other ones that came out with a similar number to what Health Capital Consultants came out with mine. The one done by Mr. Hillman's expert, there was no comparisons. And there was no basis. And quite frankly, it was in violation of the federal laws for how you value a physician's practice and should never have been admitted as evidence. And so it was a violation of the Medicare fraud and abuse. And I'm sorry, it was a violation of the Medicare Fraud and Abuse in the Stark Act.
So just to be clear, your valuation expert had a different number than Mr. Hillman's valuation expert at trial.
Yes, that one did as well, but he also missed most of the chicanery with playing with the numbers too. So he was outwitted by them as well.
But when the granddaddy of valuation figured it out, they just looked at what had been presented at trial, right?
No, they did an independent evaluation of my practice and my numbers and went through all of my books. So they did their own unique evaluation.
But how do they know? How do they know what the husband did by looking at your books?
I showed them all the. They looked at all the valuations as well as doing their own independent one.
Okay, I think I understand.
It was a rather extensive consulting engagement.
And I'm not sure I'm not sure if you actually ever answered Justice Vuono's question. The docket says that Attorney Willett withdrew in 2013, and then nothing happens until the Rule 408 notice in 2018. What excusable neglect was there during that period that that caused that delay?
Okay, that is actually not correct, and I don't know why the docket doesn't reflect it, but Attorney Willett did not withdraw until the summer of 2019. I did file papers with the court. I'm not sure why they're not in the docket. I certainly have them, but she was considered the attorney of record, and I found that out when I tried to amend the case. They did not permit me to until she officially withdrew, and then I was able to file the motion to amend.
If we assume, just for the sake of argument, that the docket is correct and she filed the motion to withdraw on twice actually in 2013, so you're saying that during all that time you believe she was still representing you?
No, I believed it was not clear to me what was going on, and they would not permit me to amend the case because they had her down as the attorney of record in 2019.
And why was it unclear to you what was going on? This is a lawyer that you retained, right?
Yeah, well, I didn't get my phone calls returned and I didn't get my emails, and I believe she moved from one law firm to the next. So I can't answer for what other people do or don't do.
Right, but when you didn't get your phone calls returned and you couldn't reach her, what did you do?
We tried a number of times. I have documentation of how many times I tried. And the reality is that Mr. Hillman was busy litigating me. I have a very busy practice with about 2 full-time equivalents worth of patients. And I had breast cancer. I had a few other medical ailments that I'm 64 years old that preoccupy time. And the 4 children also consumed a certain amount of time. I had twins at age 41 who are now finally emancipated. Time went by. There's just a lot of things that go on when you run a full-time practice with 24 employees, 10,000 patients, 2 minor children at home.
You were very busy.
Yes. So there's only you make reasonable attempts to follow up, but there's always other things commanding attention.
I just want to forewarn you that you have about a minute left, just a minute and a few seconds left to conclude your argument. So is there anything else that you want to tell us?
I think the key is the judge made no findings as to why she dismissed the case, and I really should have my day in court and have the case remanded.
And you want it remanded so that she can issue findings for us to consider as to why she determined that your motion to amend the complaint should be denied and that your case should be dismissed, right?
No, I would like the case to go forward with the discovery and production of documents, and I need an explanation as to why Mr. Hillman and his attorneys manipulated the numbers in their favor the way they did. now that I understand business valuation in much more detail than I did originally.
All right, well, I think we understand your argument. I'm going to check with the panel and see if they have any additional questions for you. I see none. It's customary, Dr. STOTSKY-HILMAN, for someone to rest on their brief at this point. So I'm going to ask you to do that. And none of the arguments in your brief are waived. They're all there, and we'll consider all of them, even those that you didn't have the opportunity to address today. Okay?
Okay, thank you.
Okay, you're welcome. And I'm going to turn to Attorney Bednarz for to give us his argument on behalf of Mr. Eric Hillman.
Thank you, Your Honor. May it please the court, Michael Bednarz on behalf of defendant appellee Eric Hillman. Simply, Your Honor, the trial court did not abuse its discretion in dismissing Dr. Stotsky's complaint as an untimely Rule 60B motion. It's clear.
How do you know that that's what the judge did?
It's clear from the transcript that although she didn't render a written decision, it's clear from the transcript that she really harped on the 1-year limitation period here. And even at oral arguments, the appellant had conceded that her complaint was akin to and could be converted to a Rule 60B motion for relief from judgment on the pleadings. So that is within the record, within the transcript from the underlying hearing.
Was she represented by counsel at that time?
She did have standby counsel with her. She was technically pro se, but she did have counsel enter a limited appearance for that hearing. The 1-year deadline mandated within Rule 60B lacks any sort of flexibility, and trial court judges are actually they actually do not have any sort of discretion to extend those strict time limits. This case is exactly analogous to an SJC decision, Sahin versus Sahin. In that case, a husband and a wife are divorced via judgment of divorce nisi, like here. However, 3 years later, and after a very substantial increase to the valuation of the husband's business from $5 million to approximately $1.5 billion, the wife understandably filed a complaint seeking relief from the prior divorce judgment and pursuant to Rule 60B, alleging that the husband had misrepresented material facts in the valuation of his business at the divorce proceeding level. However, the SJC affirmed the probate court's dismissal of her complaint, concluding that she failed to bring it within the 1-year 60B deadline. And even though it was, go ahead, Your Honor.
I'm sorry. Was the argument made before the judge that the fact that it was not that the complaint for equity had been filed within the 1-year deadline?
Admittedly, the judge had brought that up sua sponte. That was not a point that we had raised, but I think it does have merit, and the judge did bring that up sua sponte on her own volition. And going back to Sahin, the SJC even held that despite the fact that the plaintiff's complaint was labeled a complaint in equity as opposed to a Rule 60B motion, you can't circumvent the Rule 60B 1-year requirements in seeking essentially the same relief from the underlying judgment.
But when the judge brought this up, was the allegation that we've heard about today that in fact there's documentation that shows that the complaint for equity was actually filed later than December 1. Was that addressed?
I believe it was, Your Honor, at the hearing. If you take a look at the docket, it is clear that the amended judgment entered on or is dated December 1st, and it was docketed in the underlying divorce action on December 12th. That being said,
I'm sorry, do we have the docket in the record? I'm looking for it. I can't find that docket.
I do not believe it is. I do not believe it is in the record. The court may take a judicial notice of the docket to the extent it deems appropriate, the filing of this complaint in the underlying case here was not until December 24th, 2012, as docketed. So it's still over 1 year later and still beyond the 1 year strict mandatory deadlines imposed by Rule 60B. Simply, it's an abuse of discretion standard in reviewing a denial of a Rule 60B. However, the trial court doesn't have the discretion to impose a deadline beyond one year.
So let's say if we were to determine otherwise, hypothetically, when we obtain the docket and look at ourselves, what do you say about the merits of the now framed Rule 60B motion?
Sure, Your Honor. We still think that the complaint would be susceptible to a motion to dismiss or an opposition to Rule 60B had it been timely filed. The complaint, as originally drafted, was extremely limited. It alleged that that my client, Mr. Hillman, had failed to disclose certain pension and stock benefits that he had received through his prior employer. That's simply false. During the underlying divorce proceedings, we produced, and after the complaint was filed in the underlying case here, we produced to the appellant's attorney evidence showing that his digital equipment corporation pension benefits had been rolled into a Vanguard 401k, which was subsequently listed within his financial statement and equitably divided within the ultimate judgment of divorce nisi. So no matter how the court looks at this, as whether it's under a Rule 60B standard or whether it should be more appropriate as a complaint and a motion to dismiss, we have proven that her allegations were false. We believe that they failed to meet the INAKINO pleading standards, as they were very sparse. And
you just said we've proven that her allegations were false. One of her claims is that you've converted this into that this is a summary judgment motion, and it seems like if you had to provide evidence that then we're not taking the facts as alleged in the light most favorable to the plaintiff.
I understand, Your Honor. I respectfully disagree. If it had been a Rule 60B motion, that evidence would be appropriate for the court to analyze. That being said, if it wasn't a motion to dismiss standard here, it still would have been appropriate to consider, because all the documents we had attached to our motion to dismiss were susceptible of judicial notice, because one was the underlying divorce judgment, and the other documents the appellant had received and had in her possession while framing her complaint, which is appropriate under a motion to dismiss standard to review. So it's not inappropriate for the court to have analyzed those documents on a motion to dismiss standard whatsoever. And turning our attention now,
well, didn't you also rely on email correspondence that between attorneys regarding this, and was that regarding whether or not Mr. Hillman had fully disclosed the all pension benefits, and they were within the Vanguard account? And when was that submitted? Was that submitted in opposition to the what we're calling the Rule 60B motion, or was that submitted in support of the against the motion in opposition to the motion to amend the complaint?
So we had filed a cross motion to amend the complaint in response to her motion to avoid dismissal under Rule 408. Mm-hmm. And as part of our omnibus opposition or memorandum, we included our opposition to her motion to amend as well. So I do think, we did include an affidavit from my co-counsel who represented her in the underlying divorce proceedings that simply said, this is what's been provided. It was provided during discovery, and clearly shows that her allegations in this case are untrue, that the benefits she says were not equitably divided were in fact equitably divided. And she was given information of that during the prior divorce proceedings, but continued to drag her feet for 6 years. That was provided at the initial outset of the filing of the underlying case here. After receiving that, she didn't do anything for over 6 years until receiving the Rule 408 notice. At which point she tried to avoid that dismissal and amend her complaint to include essentially relitigate the underlying divorce proceedings in saying that our client had inappropriately or misrepresented certain facts in connection with the valuation of her business and therefore committed fraud in the court and breached his fiduciary duties. So
and that was raised only in the amended complaint, correct?
That is correct. And that's why I say that her initial complaint was extremely narrow in the fact that it only alleged a violation of our client. It allegedly didn't provide disclosure of his Digital Equipment Corporation pension benefits, which he did. So turning our attention briefly to the court's decision in denying the appellant's motion to amend, it was clearly it was deemed or rendered moot in light of the court's dismissal of the action. Nonetheless, the appellant, having filed the motion to amend about 7 years after the initial complaint, when you couple that with the introduction of new facts and new theories of liability, that constitutes undue delay, which in and of itself, the court was well within its discretion to deny that motion. Moreover, it included, she further sought to relitigate the case by including allegations that we misrepresented information in connection with the valuation of her business and therefore committed fraud in the court and breached our fiduciary duties. Those claims failed, were futile as they were barred by the doctrine of res judicata and failed as a matter of law under well-established precedent. So the court clearly did not breach its or err in or abuse its discretion in dismissing or denying the motion to amend.
Can I ask you a question on a slightly different topic? How, if at all, do you think the fact that there was a lawsuit that settled for failure to bring an appeal in this case bears on any of the current issues?
Well, it's an interesting point, Your Honor, because within her initial motion to avoid dismissal in the underlying case, she had actually said in a footnote that she had filed an appeal of the underlying action and voluntarily dismissed it at the behest of her then attorney, which then, and unfortunately I checked the doc and I wasn't able to locate such an appeal, but that's what was represented to her within her filings. So any issue in connection with the valuation of her business is absolutely waived. Having a judgment having been rendered, having an appeal been filed and subsequently withdrawn. It's totally inappropriate for her to now, 8 years later, seek to undo the valuation of her business during the divorce proceedings.
Could you direct me to where there's the allegation, the statement that she filed a notice of appeal and then withdrew it?
That would be page 14 of the record appendix, Your Honor, footnote 2.
Thank you.
And lastly, Mr. Hillman, it should be entitled to an award of his appellate fees and costs in this action under well-settled SJC law regarding the untimeliness of the Rule 4OB motion and the fact that the appellant, having been provided with evidence on multiple occasions that her allegations were completely and utterly false, continued to pursue this action in bad faith. So we would request that Mr. Hillman also be provided his attorney's fees and costs. And with that, I would respectfully request that the trial court court's decisions be affirmed, and I will rest on my briefs.
All right, I'm going to check to see if the panel has any additional questions for you, and I don't see that they do. I don't either. Thank you both very much for your argument. Thank you also for your patience. Thank you for your briefs. That were very helpful. We'll take the case under advisement and we'll